Pass on the memo. Pass on the memo. Give. Pass on the memo. Yes, pass on. Please pass on the memo.
Matter under specialist item number 1.
Mr. Rautre.
W 526 of
Mr. Rautre.
Good.
Yes, Mr. Rautre. That was almost it was disposed of, but certain while dictating with certain difficulty as error, we have made. So we have brought it.
I
I think
also another note also.
I think on 7th and 8th, we are putting it on 8th.
Yes.
So for delivery of judgment.
I have prepared a note. Can I give to us? A note I have prepared also. Because you also need it right up on it.
Let's see. Along with
8th July.
and
8 July.
submitted written note of argument. Taken on record.
Tuesday is auspicious day.
If you have no objections. स्कैन करके व्हाट्सएप पे पढ़ते थे पहले रिकॉर्ड स्कैन करेंगे तो व्हाट्सएप पे फोटो मस्ट that's I look into that.
Right. Item number 1.
But here the question had earlier approached and the Lordships under Annex 11, S61, Lordships directed the Excise Commissioner to decide the appeal on the provisions of Section 75, Section 68 and Rule 58 for compounding of offences. Now under Annex 13, the Commissioner has rejected without assigning reason and not dealt with a whisper about the Section 75, 68 and Rule 58. And Lordship said Annex 13 is the impugned order 75 and the Lordship operative portion at 77. No reason has been assigned. It is written that misrepresentation of facts and incorrect pleadings rejected. My case is on the with regard to compounding of offence under Section 75. Lordship's direction was that should be considered in accordance with the law.
You are done with the
No, yes. Lordship. Yes.
Yes, madam, what the authority can he defy the order of the if there is a matter which is given that it has to be considered in the light of this observations. Can he?
Yes, ma'am. Written order submission have taken more 7 grounds. Not a single ground has been taken care of.
Okay. On Monday because I think
Yes,
shop
that
is
is-
sealed.
Yes, ma'am. They have closed the shop. 26/9 they have closed the shop. Stocks are there in the premises from 26/9, and some of them, here, Lord, it is, now it has been sedimented, Lord. Because it is 6 months validity.
Sedimented with the silt.
Yes, but it's in the seal, sir. They have closed the shop, nurse. They sealed the shop and the stocks.
No, with the silt.
No,
I'm
it's not.
talking about with the silt.
No.
I mean the dirt.
Yes.
What are they doing? They have to remove the dust, which is accumulated there.
There's a lot of illegal activities going on there. The collector says so, your lordship, it come on fourth level. An instructor.
This has not been done since September, so how you expect
Lord.
that within 5 days it will be?
The collector has written on 29/3 March, Lord.
So now we are in the month of June,
Lord.
July, we have entered.
Against that order, Lord, I have approved, so Lordships. Lordships have disposed of that.
They will take it also.
Yes, I understand, Lordship.
But later, they know it.
They won't pay.
Yes, yes.
Yes, all the names.
Item 2.
My lord, this is a cover.
Service upon the advertisement.
This is covered matter.
ESG.
I'm not it, sir. No.
It's a local,
Right.
is a state act or a central act?
It's a state act, covered matter.
State act, then the advocate general is to be notified. They are challenging the violations of certain provisions of the excise. All the needs.
My lord. Item number 3.
My lord, create the similar order be passed. This is a similar order passed.
TML, this is the case you have challenged the virus, so the virus will be there.
My lord, in a similar matter, your lordship has been pleased to pass this interim order.
This is not interim order. See, the instant petition is filed by the petitioner, sealing the virus of clause, Roman 3, which is matter B or part B of the excise.
Just advising. Well, in young counsel while citing, it will be careful what is done. If it is done, cite.
Item number 3.
This is regarding a contract of.
You are already an existing contractor.
Yes,
You wanted to challenge the entire SIT.
no, the reason I have not participated in the next, the reason why I just,
You do not have a turnover of.
because I'll just will not explain subject to your lordship's indulgence. If your lordship should come to page 39. That's the first tender in which I was selected. That was 10 crores. No, in 2025, again they floated another tender because they were extending in the third year month by month. So there also they mentioned it as 10 crores. And the annual, well, not the billing cycle is about 1.35 crores every year, so far as that institute is concerned. And what happened is in the 25, in the second tender when they floated, there were three competitors. I was L3. But L1, L2, what they had done is because everything is on, online, everything available to all the documents, they categorize the highly skilled workers as unskilled. So the price becomes less. So I made a representation. And on the day I made the representation, they cancelled the tender. On 19/5, my lord, 19/5, they cancelled the tender. Then the first tender has been issued for the very same work. No deviation, nothing, and now they have raised it to 50 crores turnover.
That's absolutely a policy.
No, my lord,
Can support that raising of a barrier, does it mean that the court will interfere?
No, my lord, provided it has a nexus with the purpose it wants to achieve.
If they want it, because they will.
Lord, in a manpower service, your lordships knows that 50 crores is either they want to eliminate people or they want to choose a.
You can say that this is absolutely unreasonable.
And absurd.
Irrational in the agreement, whatever, but you know, is within the domain of law.
That I understand, my lord. That
If nobody participated, because according to you, it is impossible to perform. Then in that event, nobody will come.
no, my lord, the
They have to
very
take a course.
no, because if the same clause, because since I raised the objection,
Difficulty in floating it. If you meet the requirements, fair enough. Others may not meet. If everybody does not meet the requirements,
my lord,
it could be a farcical approach.
the judgments also, my lord, of the Honorable Apex Court says that the conditions which are imposed in the tender bid document should have a rational nexus with the purpose it wants to achieve.
That is what is there. That if something is imposed here, only question of the minimum this quantifying a particular amount.
Yes,
This quantifying an amount cannot be said to be in that sense. Other conditions which are impossible because in the sector, the Supreme Court in innumerable judgment has said the certain conditions which is impossible to perform and which is not having no nexus so far as the work is concerned. Then in that event, the court may interfere. But this is nothing. Because the 10 crores was earlier, now they wanted to raise it to 50 crores.
they brought the new with 10 crores. If I would have not made the representation, they would have given with 10 crores to the L1.
Because they find that something has happened in the meantime. So they want.
My lord, the scope has not increased. The institute remains the same. It's a small institute, hotel management institute. The lordships knows it's not a work which involves multiple sectors or multiple locations.
Whatever. Cannot be said to be absolutely unreasonable. Where is the new one?
New one, my lords, that's at page 99 if your lordships should come. For the very same period, everything is remaining the same.
That's true. They scrapped the earlier one. So that was a respite to you because you were L3.
Yes, fine.
So you did not bet that you have been deprived.
No, I'm not on that, my lord. That is because I can't now qualify, so I can't apply also. Page 99, if your lordship should see at the bottom, financial capacity. For the same tenure which they wanted in the previous also. If your lordship should come to vis-a-vis that the page 63, which the tender which was cancelled. Then on the next, if your lordship should compare it with 1.1.8, which is at page 100.
We have said that in any of these 3 years, if you have the turnover of 50 crores, that's enough.
On the next page, my lord, it says in each of the last 3 years.
So,
On the next page at page 100. So, and in the previous one, if your lordship should come to page 63 in April, which they brought out the tender which they cancelled, it was, my lord, minimum turnover of 10 years at both the places.
yes.
We have the copy on this. That day, GSGA was there. We sought for the copy and we have served them the copy also of this very same.
TSG.
The Hotel Management Institute is under the central committee. I mean, that's what he said and he accepted the copy.
CGC or Shannon from Central?
I am from Senior Finance Council.
He is associated. He cannot.
You ask your colleague. Yes. After receiving copies, why?
I didn't know.
Yes.
ESG in the office. But my lord, he happens to be my associate otherwise, so.
He's CGC. That's why I'm asking the two.
I didn't know.
There is no bar.
No, there is no bar, my lord, but propriety, my lord, since I am appearing in the matter as my office. Subject only for this purpose.
No, it isn't.
Deeply applies. I'm sorry.
We have.
Oh, I'm sorry, my friend, I am. 2 o'clock, my learned friend would be there. My learned friend would
doing it.
no, my learned friend would be there. Your lordship may keep it, pass it over.
This is the matter.
This is the issue only issue. There is nothing
No, I
else.
have seen. That only. Where is the DSG? Not the DSG. And you call it, we are making a Passover.
Dear my lord, continued petition before my lord. petitioner got license for IMFL offshore,
Onshore or offshore?
offshore,
Offshore.
madam. With regards to places like Fuladi, Patrapada and Baramgadi, 3 places. Madam, he could not operate because COVID intervened in the meantime and government directed to close all the shops. So shops were closed from 5/5/2021 to 19/5/2021. And with regards to Fuladi,
Only for 14 days.
my lord, here for 14
Oh,
days.
20, oh sorry, yes, 21.
My lord,
Is there?
my lord, with regards to Fuladi, the local people objected, for which the shop was closed for 8 months. A different place was given. My lord, to waive out this MGQ and license fee for the period 8 months, we approached the authorities, they refused. We filed a writ application before this honorable court. I filed a writ application before this honorable court. My lord, that is annexure 3. Order is annexure 3.
Nowadays, lot of matters are coming, and there is a uniform, the direction which is passed, that whatever the shortfall which is there, you can lift in a subsequent within a particular period of
My
time,
lord,
so that there is no difference.
my lord, I'm ready for that. And my lord, the body they are claiming, my lord.
Order in this regard,
My lord,
that whatever is the shortfall,
my lord,
you will lift it
My
along with the present one, and then
My
there is no difference.
My
Yes, madam.
Your Lordship,
with regards to
that
the,
is the
with
case,
regard,
Your Lordship, for renewal of license. It is
Oh,
WPC
it is
number,
not renewed.
no, Your Lordship, because WPC number 31035 of 2024, which is now sub judice before this Honorable High Court. In the said writ petition, the Honorable High Court had passed an order dated 13/2/2024 to obtain instructions whether the petitioner will produce demand draft of rupees 6.50 crores, being
Well-
50% of the excise duty demand on the agenda, but till date, the petitioner has not given his consent.
What can be done?
my lord, peculiarity of the case is, the writ application was
Then it's
pending.
a different case, otherwise in most of the cases.
My lord,
Now.
what has actually happened in this
The
case?
fourth round of litigation, Your Lordship.
Yes, no, it's 6.
Two shops, they are not allowing lottery for those two shops. They have closed down for the past 2 years, Your Lordship.
My lord,
Government is losing revenue.
I'm-
He's
I'm
coming
ready to-
on and off, fourth time litigation, this is the fifth litigation.
my lord,
Good for you.
Not good for me, good for them, Your Lordship.
But good for you.
I was, party to one.
my lord,
Orders.
Your Lordship, I may hand over
Yes,
the
13
orders.
39.
Case 39, please come.
Yes,
Yes.
the order of the collector is also there. where-
When I'm not asking you to come to case 39.
Paragraph 1. The results of the petitioner would like recommend court to close this off due to the public pressure. 39.
Yes, Your Lordship.
The paragraph.
Yes, Your Lordship.
The relevance of the petitioner is that having. the
Forced to
court-
close the shop due to public pressure, he should not be asked to deposit. No, Your Lordship, this is,
To deposit the duty of the
yes,
MGQ during the closure period. That is
you-
given.
no, Your
There are-
Lordship.
till date, my lord, this order has not been compliant.
That we have mentioned about a similar matter.
Yes, Your Lordship.
Then we have delegated him to seek appropriate remedy.
Yes, Your Lordship.
But
And
thereafter
not,
this,
before with, Your Lordship was a part of the order before Justice, Dr. B.R. Sarangi, Your Lordship, had given a copy of the order where, he was asked that in view of such position, this court disposes of the writ petition permitting the petitioner to deposit the requisite fees along with statutory dues for running the shop on renewal thereof, and whatever shortfall MGQ are there for the previous years, 21, 22, 22, 23. The same shall be spread over to the next excise year.
continue with the business
Yes, your
and
lordship.
there pay all the requisite license fees?
Yes, your lordship.
Has he paid it?
No, your
He
lordship.
has not.
The peculiarity of the case is, first order was passed by my lord.
What is your justification to an order of
My lord, they have not,
dated 6/4/2023? Tell us what
without
is your
waiving the order, without waiving this period, 8 months MGQ
I am
and
simply asking you, when you did not assail in this order, you did not say anything. This order is very explicit on the face of
my
it.
lord, what happened?
I do not know what has happened.
But I
uh,
draw the authority, attention of the authority about the order which was
in view
passed
of
by
the
my.
petition, this court disposes of the writ petition, permitting you to deposit the requisite fees along with the statutory dues for running the shop on renewal thereof, and whatever the shortfall and MGQs are there for the previous year,
My lord,
the same shall be spread over
yes, my lord.
for the excise year 2023,
My lord.
which as we were saying, you say yes, yes, yes.
Yes,
So this was done.
my lord. It was
Have
not,
you-
it was,
Have you completed or not?
I have drawn the attention of
I
the,
am asking you, have you
Well,
have you complied the order,
I will,
paragraph 6 or not?
my lord, my humble submission before my lord is, initially the order was passed by this honorable court by my lord, my lord, where they have, where this honorable court was pleased to observe, my lord.
Both the cases, the appearing counsel was the same. And subsequent order he considered. In subsequent case, he considered.
My lord,
So this order was passed.
my lord. And
The another order.
with regards to spreading over the system, my lord, they didn't allow me, my lord. It was
Sir,
not allowed.
I
I'm
wanted there
today
are-
also, today I'm prepared to,
Sir, there are twin directions.
Madam.
One was to pay all the statutory dues and the licenses. And then the second part was that you did this left out
my lord.
MGQs
Madam.
spread over to the year 2023,
Madam.
2024.
My lord,
Tell me that you complied with the.
My lord, I'm coming to that, my lord. Initially, on 19/1/2023, my lord,
It is substituted by a latter order.
Yes.
Which will prevail.
my lord, but they didn't, this, my lord, deduct this MGQ, which they were demanding for 8 months, my lord. Though it was specifically stated or directed by the honorable court, they didn't deduct the same.
What is specifically directed?
My
Have
lord,
you deposited your statutory dues?
not being asked to deposit MGQ duty for the
Sir,
closer.
I am simply asking paragraph 6 of this April order.
My lord,
I'm reading for your benefit. In view of such position, this court disposes of the writ petition, permitting the petitioner to deposit the requisite fees first, along with the statutory dues for running the shop on renewal thereof. This is the first condition. Have you complied that?
my lord, we have complied this order.
I am
Our license-
asking, sir, I have read the conditions. Have you deposited the requisite fees? Have you paid all the statutory dues?
My lord, I have deposited the requisite fees and my license was,
Let them that you
Page
you
34.
also deposited the statutory dues. Have they? Madam?
page 34, page 34.
Your lordship, total by 5/6/2024, the totaling excise duty was 13 crores 66 lakhs 6,536, your lordship. And for
Madam,
the past 2 years, those shops have been closed.
They did not.
And no, your
After
lordship.
this
And
6/4, they did not. Now, the second condition was, and whatever shortfall MGQs are there for the previous year 21-22 and 22-23, same shall be spread over for the excise year 23-24,
Yes.
along with the MGQ of the current year. So shortfall you can make up during that particular excise year 23-24. That was also permitted to you.
my lord,
Now the question
Madam,
is that have you?
my lord, see page 34. My license was, I deposited the license fee.
See,
deposit license fee, and it was extended from 1/4/2023 to 31/3/2024. But they did spread over the system.
What?
My lord, I deposited the amount for which my license was renewed from 1/4/2023 to 31/3/2024. And but MGQ, my lord, it could not be spread over. At present, my lord, I am ready to deposit, my lord, property security worth 30 crores, my lord, which law says they can also take possession if I will not comply the order of this honorable court. I am, my lord, if the order will be passed in that aspect, my lord, that I will leave the quantity in question. And
Deposit the entire 13 crores dues.
My lord, what is happening, my lord?
Within 1 week from there.
My lord, what is happening, my lord? This court was pleased to direct 6 crores, but I could not arrange the money, and I have obtained instruction that if it will be supplied to me within 3.
Then who is to be blamed for the same?
My lord, the property which I want to give on place before the authority, around 40 crores, but nobody is prepared to take the property at present, my lord. I am ready to pledge it before the authority. And if I will not comply the same, it may be taken up. It may be taken, it may be seized by them. It may be, they may recover everything from our property in question. Instead of 13 crores, I will give property security worth 40 crores. But bank is not giving money with for the excise things, madam. For that reason, madam, he is unable, madam, to pay the amount. And madam, I have obtained instruction to the effect that if this entire thing will be spread over within 3 months, in each month he will pay 2 crores.
It's a very unique way of putting the things. Let us hypothetically examine this submissions.
Money.
The government collects the taxes, the cess, the duties for what? To return to the citizens.
Yeah.
To
For the benefit.
enhance the benefits. We do not pay an income tax. Earn crores, purchase some property worth crores, and at the time of payment of income tax, you say that I am putting my one of the property which will cater the entire tax. Keep it. I do not want to pay money. If every citizen of the country starts doing it, then imagine the situation that how the country would run.
Or one thing when I do is I will pay money in the
Show the color of money to them. Whatever is the dues, you deposit that money, you are happy. No collateral security. Nothing of that kind can be.
Right now, my lord, within 1 week, I will pay 2 crores.
No, you can't bargain with the court.
It's not a question of bargaining, my lord, because question of
that is, you show your bona fide. There is a statutory dues hanging over your head. Liquidate. The only leniency the court can extend is to give
one
you
thing.
time to deposit and liquidate the money.
One thing I want to.
You can't take the authorities for a ride.
No, my lord. With regards
This is
to
what so many litigations are coming. The courts are passing an order. Courts are giving you. I would say they were more considerate. Though I personally believe no, but still some discussions was exercised in your favor. And still you are not.
my lord, one thing I want to draw. I will last submission. Last submission.
Trying to be
My
able
lord,
to pay a single penny
last submission.
of his
Maybe pardon, my lord. In page 112, make I visit. Which ballot? 1 minute. Ballot, I know, ballot.
I have given.
Annexure 17. Ballot पे kindly see.
Enough opportunity.
Ballot पे kindly see page 112.
Whatever.
I applied on the RTA whether you have waived the ballot with regards to the closure period. They are saying yes, but now they are claiming 13 crores. Ballot पे kindly see this.
Nothing.
During-
Nothing you'll have to show. If you show your bona fide.
Ballot पे kindly see. We have drawn the attention of the authorities.
Definitely.
We have drawn the attention of the authorities, but they are not. Ballot पे kindly see. If maybe and page 112, annexure 17.
Do one thing, you continue and make a, the tender for inviting the
On
applications.
4th, your lordship, the lottery is to be held on 4th of this month.
What is this concept of lottery? Oh, means the applications are there, but then you put a lottery, whoever is lucky enough to get.
Yes.
Okay.
There are around 30 to 40 applicants, your lordship, for these shots. And moreover, your lordship, an order of the collector, section 251 says all appeals from the order of the collector will lie to the commissioner.
But order of commissioner has also been passed.
That is in another case. They have challenged and again they have come challenging.
Oh, the order of commissioner is also.
Yes.
Earlier also it was challenged. The
And-
commission passed the order that they came on the to the court. The court again sent it to the collector. Again they have come here.
So this time the commissioner has not been approached
No, directly to the
directly from the collector. Show me that notes. Delegating him to go to the collector. What is that order?
The lordship,
Yes.
the order of the collector, there it is reflected that in WPC 14365 of 2024, on 19/6/2024, the court passed an order as agreed by the learned counsel for the parties, and after going through the records, this court, without expressing any opinion on the merit of this case, disposes of the writ petition, directing the opposite party number 3 to consider and dispose of representations filed by the petitioner series under 7 series and pass appropriate is possible 3 months from the date of production of copy of the sample.
Now this order is issued.
Yes, sir.
Here. That is answered 18.
Yes, your lordship.
This is the opposite party number 3. Collector,
Collector, your lordship.
can we go above the order of the commissioner? Commissioner is an appellate officer.
Your lordship, commissioner had
Why,
passed.
what is the purpose of relegating him to a collector? Can you take a contrary view?
Again, a representation that was filed to the commissioner,
Order of the commissioner, which must have been challenged in that.
Yes, your lordship, it was
Challenge.
challenged in WPC number 12116 of 2024. Again, this was disposed of.
Where is that?
Your lordship,
It was, The 15/5/2024 order.
Yes, Your Lordship. That again was challenged, whatever the commission, again, it was, the court held that the representation filed by the petitioner shortfall, the commissioner again, after hearing the representation on 27/20.
Order of-
Again, commissioner passed an order on the representation. That was again challenged in WPC number 31035. Where the court held that you have to pay 6.50 crores, that is 50%.
Up to obtain instruction,
Yes,
not to,
obtain
you have,
instruction,
you have to
Your
pay.
Lordship. And that is sub judice. Again, they represented before the collector. Again, they have come before the High Court. The court has ordered that the collector to dispose of representation. This is the disposal of that representation, Your Lordship, or they come before this.
I'm really surprised with this. Sometimes they make a representation to the commissioner, sometimes they make a representation to the collector, and the court is mechanically passing an order you consider.
Past 2 years, no record.
Is the higher authority
Well, a file,
hierarchy of the system. And if the commissioner has already taken a view, can a collector take a different view? Being subordinate in rank.
Moreover, that case is also pending. Subjudice.
pending disposal of the application before this honorable court, this order has been passed. And that too by, not by the corrector manner.
Do one thing, can you give me a chronological event?
Yes, yes.
With short notice. That is, the quotas has to be achieved for all time to come.
Tomorrow I'll find.
File it. With the relevant, the writ petitions with the relevant prayer, each writ petition in a chronological order,
Yes, Your Lordship. I'll.
first, second, third, everything.
Yes, Your Lordship.
And then what is the gist of the orders, please quote that. A comprehensive chronological events in relation to a.
Online and that's all.
What I know. But he's not. He's not connected. Online, must be there in the court. DSG. Has he not come to the court?
Today, let me keep it to
Though I find many a times they are sitting in
their office.
office, yeah,
Yes.
and then arguing. Any option?
Well, so he's not responding.
He's not responding.
Tomorrow, you're not.
Tomorrow.
I'll be talking.
Yes.
Item number 5.
Whose order?
Order 6-2 to
Whose order?
I have missed answer one.
It will listen to us. That's it. Yeah. Then you are, you are saying, yes. Yes, what was the direction for us?
And the para 10, in view of the fact and the law discussed the above, since the order.
Without assigning a reason, the same is here. Consequence is for, the matter is related to the authority to take a decision in accordance with law. While passing the reason of that, what a contempt.
Within the order was passed to be and they have
To
to
the contempt,
they have issued another tender notice, madam.
Sir,
Yes.
is it a contempt jurisdiction? There is nothing, the time bound or time limit which is indicated in the order. Nothing of that kind. How the contempt lies? Tell me.
Thereafter,
This order was passed in the month of February.
Honorable Court directed to take
Dispose of in accordance with law by passing a recent order. There is no timeline within which it has to be done. I can appreciate that you are coming, that look, the deadline was given of say 4 months or a 2 months or a 1 month or 2 weeks. They are not following that deadline. I can appreciate. When there is no deadline given,
without passing the order, they have
you
issued another tender.
can you maintain a contempt? Is it a forum in this regard? Tell me. You know what can be done in this regard.
Then another tender notice was issued.
You could challenge the tender there. That action that cannot be done in a contempt. The contempt jurisdiction is squeezed to only one. Whether there has been a willful or deliberate violation of an order. Secondly, ancillary to it is that the court can also ensure the due implementation thereof. Nothing more than that.
That tender was also considered. That consideration which are.
We do not want to give a notice. We are discussing here and now. All
Yes, memo. Right of objection.
So in this case, the petitioner is a primary waivers cooperative society. The primary waivers cooperative society means there are several self-help group SAG who works for waiving of handloom products, mostly saris. And the opposite party number 3, that is the government agency Millards, Boyanica, they procure the handloom materials from them. And as per the entry list Millards, we pay 2.5 to the central GST, 2.5% to the state GST. Suddenly, Millards, one so-cause notice was issued and a consequential order was passed, where the assessing authority gave an opinion and alleged that I do some kind of works contract and they calculated the GST to be 18%. But while they made this calculation, Millards, they have not given a single document or a single allegation to show that there was any kind of works contract involved in that thing. Then, Millards, the so-cause notice as well as the order Millards, both of that is ex parte Millards, because the self-help group women Millards, they are from Atagar Tigiria, which is almost 60 to 65 kilometers away from the headquarters, that is Cuttack, and they are dependent upon a tax consultant who lives here. So for that reason Millards, I have taken that ground in the rectification application also Millards. In the rectification application, they have not given me a single opportunity, but just given and concluded it as the rectification application is unsatisfactory. Before stating that Millards, in 3 of these stages, I have not been given one single opportunity. So I humbly seek Millards, our High Court, in similar circumstances, passed an order where our High Court has given stated that at the time of rectification application Millards, one opportunity at least may kindly be given Millards. So
you are an organization of a self-help group.
yes, Millards, cooperative society.
Cooperative. So it is really a cooperative of the several self-help groups.
Self-help group. Yes, Millards.
Self-help groups.
Yes, Millards.
So what are you earning?
Yes, Millards.
Certain margins?
If your lordship will see, Annexure 1, that is the registration certificate, my lords. In page 17, the nature of my service is already there. And the nature of service, my lords, page 17, my lords. Factory manufacturing, retail business, office, sale office, recipient of goods and service, wholesale business. It is already within the knowledge of the assessing officer, my lords. Despite of this fact, my lords, they have concluded that I am doing some kind of works contract, but no, without any documents or without any evidence to that effect.
Yes.
Your Lordship, page 30, Your Lordship may kindly look into it. So far as the assessment order, Your Lordship. Your Lordship, so far as the opportunity has been granted to the petitioner, Your Lordship, the below paragraph, the said taxable person, Your Lordship got it? The said taxable person chargeable with tax, interest, penalty issued with a show cause notice on dated 30th May 2024. But the taxpayer neither submitted any reply nor subjected to tax. Hence, the taxpayer given.
But here is the same.
Your Lordship,
Every time I am expressing this view.
Your Lordship, particular dates.
When is it served?
Your Lordship, this is in the portal, na? The stuff on the same. Your Lordship, 169(1)(d). The portal service, Your Lordship. I admit portal service. 169(1)(d) is a valid service, Your Lordship. So same day served. Once it has been uploaded, means it is served. Your Lordship, this is a there are category of judgment.
What
Your
was
Lordship.
what was the time gap between the uploading and the date fixed for hearing?
Your Lordship, the show cause notice is annexed. Your Lordship,
May I
that
submit
is-
one?
Your Lordship, Your Lordship, Your Lordship, that is at page. That is at page, I'm sorry. Your
19.
Lordship,
Your
Your Lordship.
That is.
Date full, page 20.
Page May,
Your Lordship.
30th May. What was the timeline given?
Your Lordship, timeline has been given personal hearing 1/7/2020 for the next page, page 20. Page 20, Your Lordship, there is a table.
Yeah.
In the table, Your Lordship, date by which the reply has to be submitted 30th June 2024 and date of personal hearing was on 1/7/2024. After this, Your Lordship, 3 reminders have been issued. Your Lordship, he has not cooperated, he has not appeared and cooperated. Now, Your Lordship, so far as the TDS is concerned, Your Lordship, may kindly turn to page 29.
It's a matter of only 3 lakh rupees demand.
Your ex parte order, Your Lordship admitted, ex parte order. But Your Lordship, so far as the
3
rectification,
lakhs demand.
Yes, madam.
Demand of 3 lakhs only.
Yes, my lords.
it
But
is
they
already available, Your Lordship.
rural women, my lords, 3 lakhs is a huge demand for them, my lords. And moreover, everywhere it is ex parte. My lords, in 35, they have given the so
What do you
called.
expect? What do you?
I-
This person giving a notice will wait eternally because.
No, my lords, I do not expect that. In
And so far as the
I
person-
humbly submit. In May, they are giving me a notice stating that till 1st of July, I have the time to submit any reply. Suddenly, my lords, have they given me 3 opportunities and on August itself, within 1 month, they have passed the impugned order. They are very well know.
These are.
Yes, ma'am.
And as per before the applicable.
Millets, in rectification, millets, because there is error apparent. When they are passing an order, they are at least obliged to give any.
Have this your city. You have to spoke to challenge the assessment order. In person won't do anything. The appellate authority has to appreciate your evidence.
Millets, I would like to rely on one order of our High
And the
Court. Millets.
rectification is not maintainable, Your Lordship. It has filed more than 3 months. After 3 months.
If
And
it
the
is not-
provision says.
If it is not maintainable, millets, why their officer gave a view that the rectification was unsatisfactory?
Your Lordship.
Why did you entertain?
You entertain.
Your Lordship.
After
That
entertaining,
part-
you say that.
You can't take a plea that it was fine beyond 3. You could have said it is beyond 3.
Your
I'm
Lordship.
not going to accept it, reject.
That paragraph
Millets
is
down.
there.
Not paragraph, but you have decided on merit as well.
Yes, millets.
And merit, Your Lordship.
And millets, one humble prayer, millets, if your lordship will see 161(3), which says, millets, if any rectification application is being decided on merit which adversely affect the person, at least an opportunity of hearing, the principle of natural justice is to be followed. Our order is there, millets.
What is the meaning or a concept of a natural justice? When you talk about a natural justice, Does it mean that so long it is not exhausted, entire proceeding should remain in limbo?
Yes, my lord.
That is our law.
No, my lords. What I am saying is,
If they
in
have
this case,
repeatedly given you a notice and you did not appear, you say that your chartered accountant or a tax consultant is here in Qatar, which is 60 kilometers away, not possible. How much time it takes to travel?
no, because
60 kilometers
my lords, they,
on
it
by
was not
road,
within
how
their
much time
knowledge.
will it take? You can't blame
Only
the
in submitting
authorities,
millets, there are
everybody.
similar orders of our High Court millets. This is just
Maybe give it. If I have a dissenting view, if my brother agrees, we can.
Even this order,
Again?
application order,
again.
can also be challenged in appeal.
Yeah.
As long as assessment order stays at you, the authority can be upfront his own merit, which he has decided ex parte in the assessment, in the garb of rectification.
And
What is the scope of rectification?
if there is any error
Apparent.
yes, my lord.
So he can amend entire assessment order.
No,
He will have to
in this case, the
recall
error,
and, he will
no, my lords. In this case, it is the error apparent, my lords. Can they show any single document or can they show any single para from the
because
That means it is an erroneous order which is susceptible to be challenged in appeal. Rectification means what? If there is any patent error which is apparent, that's all. That does not mean erroneous order. Does not mean it's a patently illegal order. Go there.
my lords, I would like to rely on two judgments, my lords. One is,
There is no ratio which is laid down here. You are relying on this judgment.
but this is our High Court's order only, my lords.
What binds the coordinate bench is a ratio of a law or a decision. The ultimate decision is not binding on the court. That maybe in a special facts of the case, the court has come, but the facts may differ.
There is another judgment, my lords, that this coordinate bench has passed. my lords.
I do not find there is any law which is declared in this judgment.
In this judgment, my lords,
this
is very-
input test credit, it's
Yes. This is our judgment. What you wanted to say? Show us.
my lords, yes, my lords.
Or which proposition of law is binding on us?
In this also, my lords,
Show us.
that was a single.
5.2.
It was a case of a
Single
Yeah.
input tax credit which was
Yes, my
given.
lords. Paragraph 5.2,
Yeah.
where the it is not unknown to the department that it has issued registration certificate to deal with the
That
only
was a
one
different-
commodity. In my case, they had issued with the registration certificate to deal with the.
Correct. So there is no difficulty in the registration. We have also held in a judgment that if there are several modalities is given for service of the notice, if one of them has already been exhausted by them, that's a sufficient compliance of the provision.
Yeah.
That is what we both of
Yeah.
us held.
Yeah, yeah.
So you can't say that you were unnoticed.
No, I'm not saying that, my lords, but I am only humbly praying that as I
What
have,
prevented you not to appear at all the stages?
I have taken that ground, my lords.
Say-
They had no opportunity to appear, so
No opportunity, what does mean? They will just sit over it and make an invitation, please come attend, please come and attend, and they will not
no, but
proceed.
though our High Court has not decided but Delhi High Court has given its view that as per 161(3), before deciding any rectification application, personal hearing is mandatory, my lords.
They have given a notice, it is not. When you have
No,
filed an
at the
application, they have not
rectification,
given.
they have not given any notice. At the
Show us
time,
that you have given
at the time
notice.
of rectification, my lords, they have not given any notice.
Have you given a notice at the time of rectification?
My lords,
Rectification.
no,
Or you have not given?
my lords, kind
So there's filed an
judgment, my
application for
lords. My
rectification,
humble
did you
request,
not
my
give
lords.
them an opportunity?
That part,
That you come and show that what's the error?
Your Lordship, for a moment, kindly look into 161.
To
The
us,
provision 161.
let us say no personal hearing is required, no hearing is to be given.
But just your Lordship may kindly look into.
Please.
Without prejudice to the provision of section 160
Yes.
and notwithstanding anything contained in any other provision, any authority who has passed any decision and certificate and may rectify any error which is apparent on the face of record
Correct.
in such decision or order or notice, certificate or any other document,
Hmm.
either on its own motion or where such error is brought to its notice by the officer appointed under or an officer appointed or by the affected person. Show moto it can be done, your lordship, and on application it can.
So when you pass an order,
My-
it is considered
my-
party concerned.
No, your lordship, why I am saying so? What is my
Statutory.
Your lordship, what is my understanding?
Statute provides application to be filed. If you accept that application, it's all right.
Your lordship,
If you differ
this
and
provision
pass
of-
any adverse order,
Yeah,
that's the
and first already assessment order. What understanding, your lordship, let me. Adversely
Minor,
affect
provide you
means,
3
your
minutes.
lordship, what? There, because third provision is there because on two circumstances. Yeah, I may be wrong, your lordship, but on two circumstances.
Until law. Until law.
See, on two circumstances, the 161 can be done on two circumstances. One circumstance is show moto,
That
one
motion
circumstance.
Please, Mr. Mishra,
Right.
then let me take up the brief, on the. The ratification provision is brought into this for removal of any error which is apparent on the face of the building, or if there is any medical or arithmetical error.
Right.
Can you result in
Yeah.
power to correct or remove the error
Your lordship,
can be exercised suo moto by an authority,
your lordship,
can be exercised on being informed by any officer,
right,
can also be exercised in one of the.
All of it.
of the SSC. As, approved.
your lordship,
The moment the SSC had approached the authority
right,
to pass the order,
your lordship,
constitutes an error and conduct of the system.
right,
If you reject that saying that there is no error,
your lordship.
will it not adversely affect?
Your lordship, with great respect, with great respect,
Adversely affects the right, because the right to.
already affected, your lordship,
Is denied
your lordship,
by
what?
rejecting. So in that event, the third proviso shall be activated immediately.
Your lordship,
What are you talking about?
your lordship, why this third proviso? Because two circumstances, show moto, it can be enhanced. So when it can be enhanced,
Sir, why it says? Give a hypothetical example.
Mm.
When you are saying that let us have a very
uh,
understanding of this. You have passed an order saying that, yes, they are liable to pay, say, 3,50,000 rupees as a tax. Suo moto to exercise the power and then find the, no, it was the wrong, actually it should be 2,50,000, not 3,50,000.
Okay.
Please consider. If it is 2,50,000, then one can say that it does not adversely affects their right, because which was higher has been kept lower, so it is gone.
your lordship,
But if you reject their claim of rectification, or if you enhance the content, then that will adversely affect their right.
so,
Then the third proviso is already automatically attracted. This says that you have to follow a principle of natural justice. Means at least you should give them a notice. Like now, I'm fixing a date, please come and tell me that what is the error occurring on the face of the record which requires rectification. If they cannot satisfy, no problem, you can reject it, but will you not give them an opportunity? What is the purpose of the third proviso?
my lord, with great respect, your lordship, so far as the third proviso, your lordship, when it has been enhanced, your lordship, because
Adverse
he has been,
affecting is what adversely
your
affecting.
lordship,
I'm telling you.
because he has already affected,
Sir, you came in a appeal,
your lordship,
you filed an appeal
your lordship,
without giving any notice to you that the matter, when the matter would be listed, your appeal is dismissed. Are you an aggrieved person or not an aggrieved person? Tell me.
So, but when inference of first plate authority power to enhance in the garb of rectification,
first plate authority,
then what is
the assessing,
problem?
assessing,
You are saying adjustment will enhance.
but rectification,
Adversely impacts means adversely affects means assessing authority will enhance.
any calculation, if any calculation error is there, if
Then
an error apparent on the
then
face
that-
of record.
Then that
Your Lordship, in that calculation error, if any enhancement, in that calculation,
It may be a situation where you have given the reasons that their liability is to the extent of 5 lakhs. But in the operating portion of the order, by mistake, instead of 5 lakhs, it is written as 3 lakhs. That people are liable to be 3 lakhs. Authority can definitely rectify that operating portion, saying that no. Look at the limit of the order. There is already a error apparent on the face of the record. It should be 5 lakhs instead of 3 lakhs. But can you enact from 5 lakhs to 7 lakhs by giving a further reasoning and in the garb of a rectification?
further reason cannot be.
What he says.
Further reason cannot be.
So that can be done. And if adversely affecting the rights of the parties has to be understood in a more pragmatic manner, where the party has approached the authority for rectification of an order, if he is not given an opportunity to satisfy the authority, means authority that there has been an error, and then authority of its own proceeds and then decide, and if the offense really more object of the third provision, it adversely affect their rights. He is penalized, his application is dismissed without giving an opportunity of hearing.
Your Lordship. Here the circumstances is something different, Your Lordship. Your Lordship,
Circumstances-
on
You
161.
could have given them an opportunity to say that whatever the grounds were taken does not come within the purview of section
161.
160.
Your Lordship, that's,
You could have said so.
that could have been. In fact,
This could have been said so, but
Your Lordship,
if they must be given an opportunity to,
here it has been 5 beyond 3 months.
what?
Beyond 3 months.
You're not
Your
taking that
Lordship,
ground
one
of.
mistake. Your Lordship, page
You are
57.
proceeding on the merit,
Page 57.
you are proceeding on the merit.
Your Lordship, that mistake has been
What?
committed by the
What
officer.
can be
Your
done?
Lordship.
What can be
The
done?
officer himself has said, paragraph 2,
Okay.
page 57.
You're asking for her or you're asking for?
May-
Have you answered?
How Your Lordship thinks that I am arguing for her?
Then the argument, when you say argument, say that this period of 6 months will not apply if the second proviso comes into play.
Period of 6.
Yes, will not apply if the second proviso to 161.
Your Lordship, Your Lordship,
Please read that second
Your
proviso.
Lordship, from the date of order,
No,
from the date of decision.
no, please read second proviso.
Your Lordship,
Was the ticking advantage of first proviso. Read the second proviso.
Your Lord, provided further that said period of 6 months shall not apply in such case, but the rectification is purely in nature, correction or clerical
So
improvement.
how do you know that whether it is a purely accidental, clerical, ministerial, they can come and invite your attention. So the barrier of 6 months will not apply. You don't know, they may come and argue,
From which application it is,
the arguments can be also be strong, that what is the clerical and arithmetical.
Your Lordship,
You can't shut the door.
Your Lordship, he has enclosed the rectification application. Your Lordship,
Yes. Admitted position is that no notice was given. And rectification applications, they can decide.
Your Lordship, only one opportunity. On 19th, I have to take instruction.
This internet, this considerable was the issue. Thank you. Some assessment order we have to give an opportunity.
Assessment order, Your Lordship. Your Lordship, only one opportunity, let me take instruction on particular issue, whether notice has been issued or not.
You said not.
No, Your Lordship, that may not be there. Your Lordship,
Then why we.
Only-
So much of trying. It's only because you said there is rectification, no notice was given.
No,
Your Lordship, no
rectification,
notice.
no notice was
So
issued.
no notice should have been given. My argument, Your Lordship, it is my argument, Your Lordship.
So let us decide.
Your Lordship, only one instruction, only one instruction.
Is required, whether it is.
On
required or
Monday,
not. Let us decide on that.
Your Lordship, on Monday, whether notice has been issued or not. only for this.
Just
Everything else-
before,
Everything your lordship has already your lordship passed, so only
No,
one,
we are still our view is very tentative,
your lordship.
but after reading the provisions in a more harmonious manner, what you are suggesting is unacceptable. This can't be the proposition, otherwise, but proviso has to be effaced from the book, from the statute. There was no option to incorporate her provision.
Your lordship may record on one opportunity, only 2 days or 1 day, your lordship can 1 day, I can call it telephone, your lordship.
What do you want? Disposal or you want the
I'll take instruction, only notice has been issued. Have any notice, I know, prima facie on the face of, but I want to draw my commissioner's attention. I draw my commissioner's attention as regards to this type of order. Because in one paragraph, he has said that it is beyond 3 months, and the second paragraph, he has said 9.
You may be knowing the cause, but be fair on the record.
Your lordship,
Let the record. Certain officers are there, they issue notices, they serve them. We know that. So, please, let the record in specific.
I hear 13th March, the petition have been filed, 19th March, the order has been passed.
Don't do it. Because allegation.
I get from the record.
19th March.
And I just want to draw the commissioner's attention as regards to the officer's conduct. Because in one paragraph, he is saying. Your lordship,
Yeah, so, let it be. Yes, sir. Right.
Millets may pray that recovery notice they have issued, Millets. So,
See, yes. See, assessment order we cannot touch now. And rectification also will not save the limitation of assessment order to done. Recovery shall be there. That we cannot stay.
Yes.
Item 11.
161.
no, it is RC cancellation.
Figure 161.
Manual, not specified in that.
Oh, this is item 12.
This is the item.
Cancellation.
Cancellation.
Yes.
they will be similar.
The same file. Yes, it's cancellation.
Item,
Problem this.
item 12.
And your lordship's comment is shocking to me
Next one.
because
That is-
your lordship knows very well. I am not looking into my left side, whoever may be.
Item 12.
Thank you. I'm giving a receipt because of the action of the authority violating 107, section 107, subsection 7. But now let's see that attachment has been
We have withdrawn that.
bracketed.
So, withdrawn.
They're withdrawn.
As this is the mistake committed by the officer and immediately we have taken action.
Open this cancel, so I can.
Please suspend.
Your lordship.
You were challenging this particular.
Your lordship assessment order as well as attachment. The prayer B has been allowed, so it was infructuous. Now the appeal is pending.
No, the prayer B was
About
not
the-
withdrawing the bank attachment.
Yes,
Your lordship,
And prayer B was to withdraw the
Prayer-
recovery proceedings.
yes, lordship.
So
Already-
now they say that the attachment order has already been withdrawn
Yes,
and the appeal is statutory appeal is still pending.
yes.
And they have already complied the pre-deposit conditions, so naturally you will not proceed.
no. For that reason, we have withdrawn. Your lordship.
I was looking at the multiple prayers are there, if one of the prayer is has become infructuous, that does not mean the entire petition.
Both infructuous because The annexure 2, against annexure 2, he is in appeal.
The instant retribution was filed.
Dealers on the GST Act. One email was received by the petitioner. One email was received by the petitioner on 28th of April 2025. That is annexed as annexure 1 years. So at page 40, only one line of email was there. Dear taxpayer, input tax credit amounting to rupees such and such has been blocked for GST and such by the officer, Joint Commissioner of State Tax on 28th April. Full stop. Please view your credit ledger on the portal for details. So there is no section that has been invoked while blocking my ITC. And pursuant to this email, immediately the petitioner approached the authority where he was informed that orally he was informed that because of the non-existence of the supplying dealer, his ITC was blocked in. So through the GST portal, you will see Annexure 2, he made an inquiry, and from that inquiry in the portal, he found that the GST number that is at page 15, you will see Annexure 2. The GST number is stated of that is of the supplying dealer. Yes. Cancelled
That was cancelled sumo effective from 20th of
January 2024. My entire transaction is of August 2024.
August, after that, posterior.
Yes, sir. So, let's see, kindly have a glance at page 18.
Page
18. This is the continuing part of the GST portal.
Yes.
So there is a table, let's see, financial year 24-25.
Yes.
So that there is the last column, that is status. So that is the return filing status of the supplier is filed. So if his GST number was cancelled, so moto in the January month, he has filed entire period in 2024-25. And my concern period is August. Filed.
Uploaded and accepted by the department.
By the department.
Post
Yes,
cancellation.
yes, let's see.
And you transacted during that period.
Yes, let's see. My period is only August. Entire transaction I will show you, let's see, that is next page, let's see, that is Annexure 3.
So
where the liability
be returned, he has filed.
Is written, yes.
So you have cleared input tax credit in your return.
Yes, let's see.
So with regard to this transaction with the supplier.
Obliged, let's see. So Annexure 3 is the status, that is relevant page is at 23 years. That is the liability account, let's see. The liability register is that is 24-25 August is seen that 100%. So he has discharged his tax liability 100% for that particular period. So from this, I could guess that I could submit that, let's say, that this particular supplying dealer had discharged his liability for that particular period. And his liability register is also nil because 100% he has discharged his liability and returns also filed. So he cannot be said as non-existent. Pursuant to this record, let's see, the petitioner filed a representation of the petition before the officer. That is at page 24. And another point, let's see, that the amount that 1,88,000 is an imaginary amount because so far as my purchase statement is concerned, that is at page 26. Entire transaction attracts 1,29,889 rupees of
with the
tax.
With
Particular transaction with that supply. That is 1,29,000 some odd. But here they have attached 1,88,000. From here they have received that number. I don't know. Because no section was invoked, no reasoning was given. And my application was of 3rd of May 2024. And that is still pending with the authority without
supplying me any reply to that or any reasoning so that I can comply with the any requirement of the officer. But my I can't file my returns because the blocking of the ITC. This is my whole grievance, so let's say, because representation or petition is still pending with the authority. That is at page 24.
Your Lordship, blocking of ITC is an interim protection of the revenue. Your Lordship, may kindly look into Rule 86, capital A. Here, Your Lordship, let me
Understand.
Your Lordship.
You are blocking LTC for simple reason that who is the supplier,
Ma'am,
the supplier's GST number
ma'am,
was no motor cancelled.
Your
From 28th of January 2022.
Your Lordship,
It appears that supplier continued
Your Lordship,
his business activities, charging with the GST from the others, supplying the materials, charging the GST from them. Everything was done and the periodical return is being uploaded post the date of cancellation, which is accepted. And even you have said that there is no liability which can be said upon him because he has paid the entire tax which he has collected. Now, question is that whether the cancellation was given effect to in reality or it was simply on record. No further steps have been taken.
Your Lordship, let me try to convince Your Lordship, what is the procedure of blocking of ITC? Your Lordship, the blocking of ITC.
I understand because the moment you block the ITC, his input tax credit is
And after blocking,
then they are required to pay back that particular
After
amount
after
which
blocking,
they have availed under this
Your
credit.
Lordship, after blocking, immediately initiated the assessment proceeding. Your Lordship, I
I
have
am
submitted.
asking you, sir, your really initial action of attaching the account for the such period. Sir, it appears
Instruction,
Your Lordship,
page 4,
Your Lordship,
supplier found non-functioning
Your Lordship.
without verifying.
without verifying that he is
That-
completing the return.
That has been
Then
very-
what about these annexes?
I have to take instruction on these annexes, on these return filings.
He's submitting the unloading all his returns on a monthly basis, paying
Supplier,
you an amount,
supplier,
non-functional.
supplier's return, Your Lordship, so far as the supplier return.
For advancing these documents to us,
My
you should have verified from annexes which she has enclosed.
these are I have called in WhatsApp. Your Lordship, these the detailed instruction. Let me detail instruction on the so far as the 1,88,000 is concerned. There are two dealers, Your Lordship, not one dealer. That is in the page 7. Page 7, Your Lordship. That imaginary figure, that is not imaginary.
Metro International.
Your Lordship, Metro International as well as Cerebral Trade Exchange.
But
So
Annex
no-
1 is only,
That is what.
So, Your Lordship, so far as this 86A rule 86A is concerned, after blocking, Your Lordship, after blocking, a proceeding is to be initiated, and in the proceeding, Your Lordship, he is at liberty to submit all the documents, and after verification of all the documents, the proceeding will be completed. And if not at all completed, automatically the blocking will be unblocked within 1 week. After lapse of 1 week.
Fishing and roving.
Ma'am.
Fishing and roving.
Yes,
So you will block for one
ma'am.
and unearth everything.
No, both we have blocked. Your Lordship, we have blocked
You
both.
see, your mail you did. Sister has read
Huh?
that. Yes.
That is in the portal. Your Lordship, this is the mail.
You see,
This is the mail issued by the GSTN. GSTN says that you verify your portal. So on
yourself
portal,
and confuse us.
That's
Specific.
it lecha ହେଇଛି. Look, I cannot, I'm not there to confuse you. I have,
No, you should confine to
Your Lordship, your Lordship can look into that language.
confine to your record.
Please view your credit ledger on the portal for details. So this page 4, is the detail in the credit ledger.
And it's a whole is still pending.
I'm
The
on 14.
authority
I'm also at
have not
14.
taken some
14 says
step on that.
input tax credit amounting to 1 crore 88 rupees so and so, blocked by so and so, Bhubaneswar so and so, on dated ette. Please view your credit ledger on the portal for details. And he can very well verify from the portal which at page 4 I have submitted. So this, and after this, your lordship, he has received the notice for assessment. And entire details is in the assessment, your lordship, 74, and which is the consequential of blocking, your lordship, and let him appear in the assessment proceeding. And immediately, if he can satisfy in the assessment that the date has been fixed, your lordship, in the assessment, the date has been fixed, your lordship, within 30 days, you are hereby advised to, and in case you file submission, it is the assessment, the same may be furnished on 17/7, this July 17th. So let him convince the authority that by these are the payment and I am not liable to pay. And the assessing officer can complete the assessment, your lordship. Everything is time bound, your lordship. 86A itself time bound. And our Honorable High Court has decided that.
Where is this
So the
number?
your lordship
Where is this reference number?
is
Where is that document?
that is in the portal, your lordship.
Where is that?
This reference number, this is credit ledger. BL.
That is important. So giving notice for one
No,
proceeding.
not one.
That's what.
No, you know, 1 crore 88 is the conglomeration of two figures.
You have not stated suppliers. You have stated supplier.
Page 3
You
is
see, you are blocking report. You have supplied it. You have supplied this.
Oh, supplier.
And that is why I am
Admitted.
That is why I am requiring this reference number. Where is that document? Madam, what about the other one? You have not brought any.
No,
That
Your
is
Lordship, because
satisfied.
Because-
Retaining the supplies in course of the hearing.
only,
No, you have.
This
You
notice
have-
is received. This client has received.
I
What
mean-
client has
I mean,
received.
submit Your Lordship.
You have brought what's relating to
Metro International, yes, Lordship. First one, which? First one,
Cerebral.
cerebral. You must have the instruction because this notice has been issued to you. This section 73 notice. And then cerebral part is there. Page 77, which
That-
is.
the document, I mean,
No,
supplied that document.
Yes, yes. But please return this because these are official documents. First two annexes of the alert report here.
No, it gives me a nostalgic feeling of my days over there. Pretending ignorance
No, Your
of
Lordship.
everything that.
Only- May I submit Your Lordship? My petition is pending before the authority since 3rd of May. And clearly the petition has stated that the actual amount of purchase, relevant ITC, such and such, 129, everything.
When you take a fee, that so far as a liability in relation to Metro International is concerned, it is less than 1,58,000.
Obliged, Your Lordship.
You say that how can they arrive at a particular figure? They have said that no, it is not. a-
Yes, it's now-
Alone, Cerebral also want this.
Yes, Lordship, I am obliged.
We have also taken into consideration notice also. They have
Yes, Lordship, now,
indicates that the cerebral was also indicated.
yes, Lordship, now I am,
Client either have not given you an instruction.
Yes, Lord. yes,
Or I stop.
no, Your Lordship, my submission before Your Lordship is that when this petition is pending before the authority since 3rd of May,
We appreciate that at the very
That
initial
has-
stage.
that has not been, that has not,
You started and raising a dispute on the figures.
first submission,
Then he is justifying that.
Only
something
one-
has been arrived.
only figure was justified by my learned friends. The non-existence part is still pending, your lordship.
Madam, kindly see page 7. Kindly see page 7. This you know, this is at your address.
This is not.
Pursuant to section 73 proceedings.
Yes, sir, that is proceeding under section 73, your lordship.
We cannot go peacefully.
Your lordship,
This
that is,
subsequent action of
it is
this
subsequent
party.
action,
Yes.
yes, lordship.
So, are you participating in this proceeding?
I don't have instruction regarding that, your lordship. That's not why this is,
You must have to.
because I am before your lordship regarding the petition that is pending before the authority
17th
since
June.
3rd of May, and that has not been taken care of.
And see,
17th June.
17th
June.
June.
Where is the date? Where is the date?
Your lordship, page 5, page 5. This is annex to page 7. Page 5 is
17th June
the
2025, your lordship.
Page 5 is the initiation.
date,
Yes.
your lordship.
That is the initiation.
And this is all India.
Correct, she is correct to that extent, because this is of the month of June, and they have filed their petition in the month of May.
And
That is
this-
on 13, so it was non-existent. So if the thing which is not in existence, how they come to know?
Your lordship, at the time of filing up, read petition, this was not issued.
And
This was issued.
Subsequently, your client has not instructed you.
No,
With
you
regard to
have-
this.
No,
proceeding.
your lordship. Only that annexure 4 is still pending, that was my instruction. Because in all the grievances he has made before the authority is still pending.
Even this is the information, this is the alert.
You take instruction on this. With regard to cerebral.
Pardon, your lordship.
You see, page 8, madam.
Yeah, of this instruction, your lordship.
Now, this is document is given to you.
Yes,
Please see page 8.
yes, your lordship.
Yes, there are 8 transactions in.
Pursuant to, yes, 188, it is, yes, it is clarified.
Cerebral.
I
You
got
take
it.
instructions, as you have taken instructions with regard to metro, you take instructions and come back.
Yes, sir.
Let us notice, I may be permitted to take annex to 1 back from
Okay.
her, your lordship, because that is all India report, your lordship. And where his name is there at page 3, so all others names are also there. And only annex to 1, all other document.
Why it's immediate or something.
Your lordship, only annex to 1. it's all
Not as required, you file it on memo.
Because only to your
You have not
lordship.
filed any affidavit, you can file it
Your
on
lordship.
memo. As much as required. also.
I'm sorry, because
Do that, you take that. It is not required.
and at page 3, petitioner's name is there, and it is all of the.
You take it, post it, it's not required.
Your lordship.
So. File a memo. That is something. You have got the instruction, you can pass on that. You will take instruction on page,
Yeah.
page 7 and 8.
Your lordship.
So matter where I have alleged that there was a violation of section 62B, where basing on a report, the state authorities have already assessed me. I have gone around appeal has been confirmed. I approached this honorable court, I paid the balance 20% and that's kept pending till constitution of the tribunal. And subsequently, my lord, the central authorities to the self-same turnover, they initiate a proceeding and they have passed an order which is the included at Annex 1. And this, I had on the last occasion pointed out that
That once the state has already initiated,
Proceedings.
then the subsequent.
on the same subject matter, the subsequent proceeding is not warranted. My learned friend wanted to take instructions.
The Lordship asking the Lordship are directing me whether the proceeding was started by the state GST first or central GST.
Correct. So it
In
appears
this
that the
regard-
state has started first.
No, in this regard, we have started the proceeding. The Lordship, I got the instruction from the,
But have you implemented it to the state? Not to
What they have done, not subject to correction, my lord. In 2021, a report is sent to my officer because I belong to the state authorities. That such a
Your registration is dealt with by state.
by the state. So the DGGI and their officers, they give a report to their authorities and simultaneously to the authorities of the state, who are my assessing authority. So basing on that report, my lord, they initiate the state authorities, initiate a proceeding under 74 by calling me to pay up whatever demands are there by issuing me a form DRC 01A, which is a precursor to an initiation of a proceeding under 74. I give a reply, they are not satisfied, they initiate a proceeding under 74 and concluded. After the conclusion of the proceeding, I go up in appeal. I take that proceeding further, so far as the state authorities are concerned. Now, as the matter stands off now, my lords, the matter is pending till the constitution of the tribunal. I have paid the three deposits, whatever was directed.
Appeal also was dismissed.
Man, appeal was dismissed.
Then against that, the tribunal, but you have deposited.
I deposited 20% for
non-availability.
months. At that relevant point of time, it was 20%. I deposited it by virtue of the directions of this honorable court. The writ petitions were disposed of, observing that it will be till the constitution of the tribunal. This matter will be kept pending, subject. My lords, if your lordship would permit me, this was the order in Ma Tarini Traders.
in order to avoid a concurrent proceeding to operate for the same things, this provision was introduced that whoever has activated the process of law, then his jurisdiction would be there. You can't say that the order of the state is without jurisdiction. He is otherwise having a jurisdiction, but was not competent to initiate the proceeding because of that.
My humble submission.
What will happen?
My humble submission.
The entire exercise of assessment and the dismissal of the appeal.
Here, this may not be,
My humble submission will be that particular situation
may
may
not,
not arise in this
may not
particular
arise
case.
here.
Because of the fact, my lord, that if CGST authorities were sanguine of the fact that since they have initiated the proceeding first, they should have taken it to the logical end. What they do, my lord, is they give the
That
state.
is what, probably what you are arguing.
Man,
You have to support with the precedents of the Supreme Court. I am telling you, this is such a gray area one has to understand. If you, then first and foremost thing which is required by a court to determine is that what should be the meaning
connotation.
word initiation in view of this provision.
True, man.
First,
Man.
initiation has to be considered. It does not really depends upon the conduct of the parties in order to ascertain that what is initiated and what has not been initiated. It does not depend upon the conduct. The moment the proceeding is initiated and the court arrives at the decision, that's the end of the matter. Now, question that will arise that we are issuing a summons, we are issuing a notice, we are issuing a something, whether that would be construed as an initiation. And secondly is that whether we can take a very conservative view of the word initiation in view of the special fact which emanates from this case, where though the initiation was done later, but the proceeding was proceeded and culminated into the final order. In that event, in a special circumstances, what should be the role of the court?
So what your lordship would have to precisely decide what is the connotation of that word initiation.
Absolutely.
And the lordship would appreciate the similar problem arose before this honorable court in another matter, of course, remotely connected to this, where an audit was completed by the state authority, depending upon the report of the central GST authorities. The period involved was 1718 to 2021. So this honorable court found that for 1718 and 1819, audit proceedings were already over, and the petitioner chose to pay up that amount for these two periods. There, this honorable court, they relied upon GK trading, the lords of the Allahabad High Court. If your lordship would kindly take up the order of this honorable court, there this Allahabad High Court said that these words, proceeding, subject matter, inquiry has not been defined under section 2 of the GST Act. And if your lordship would kindly take up that.
No, tell me.
And there, paragraph 10 of that GK trading, which this honorable court quoted at page 4, may I just place it.
What it says?
It says, my lord, that this word inquiry or summons, which was done by virtue of section 70, is not synonymous with proceedings. So the proceedings is much later, where a particular section is invoked. Now, supposing there are certain precursor requirements, 73 or 74. So an audit is necessary, an inquiry is necessary before they put me into the slot of either 73 or 74. So once they trigger this 73 or 74, that is the proceeding initiated, because that will culminate in an order of assessment or a demand. So what they do prior to that at point of time, that is issuing of summons or gathering of information or giving me a personal hearing.
So according to you, that is what I just indicated also. That there are 3 stages. One is a stage which is
stage 1 is inquiry.
The stage where they contemplated to initiate a proceeding. The stage at which they contemplated to initiate a proceedings. But whether that can be said to be an initiation of the proceeding, as you say, the audit, then there are several things. These are the
pre-requirements.
These are the stages in contemplation to initiate a proceeding under section 73 and 74. In contemplation, please consider, because what we are thinking. And second is that after whatever they have taken, and then a note, so called notice is given under section 73 or 74. Now, which date would be considered to be an initiation of the proceedings? That's why I'm saying it has to be construed in a more pragmatic and a practical manner, and in the particularly the fiscal statutes, the role of the court in interpreting the provisions are well known.
No, in this,
That's why it has
in the
been
present
decided.
case,
It has been decided.
in the
Now,
present case,
the question is that if we want to take a different view,
your lordship can.
then we can.
It's open to your lordship. No, your lordship would see the facts.
case.
No, your lordship would also appreciate the facts of this particular case. What has
That is what I was saying, that this was a peculiarity of the facts,
True, man.
where on the basis of a particular proceedings, the state proceeded and culminated into an order, affirmation of an order by the appellate court. Now the tribunal
By virtue of the-
is pending. But here it is still at the very nascent stage.
True, man.
Is at the nascent stage
Nascent
because authority has not been able to decide it
It's
finally.
it's still stillborn.
So in order to avoid a conflicting decisions, in a special facts of the case, what should be the role of the court?
The role,
I wanted.
the role of the court, my lord, in this particular case is
Not
what
very
they did in
simple.
2000.
Not very simple.
No,
question to answer.
I'm not. It's also a privilege for me to answer your lordships. And in addition to it, I have already reversed. I have already reversed, my lord, this ITC pursuant to this. What has happened in this particular case is 2019 date which my learned friend has given is the issuance of summons to those parties
Please
to come and depose.
I'm ready on an interpretation of a statute.
Like,
In a
so
situation like
for
this,
dates.
please come and
My learned senior might help me.
29 STC.
Yes,
29 Allahabad. Two different.
that is Supreme Court judge. You resolve, please. 29 district.
Allahabad, I think.
Allahabad is the who is taking initiation of the first place that was there. So my theory is that even if I go without going to the particular, the general theory principle.
No, we want to decide that issue.
That is 29.
And there, my lord, the vice, my lord, subject to correction. Section
Yes,
2(6), my lord, gives a cross empowerment to both the authorities.
Sir, the Feroz Kumar case which is there, the 37 STC, 533, they said that one sector cannot another sector do because the sector 2 and 3 is the assessment were there. The 3 had assisted, the Supreme Court said no. Because even if the concurrent jurisdiction is there, still the person which has been allotted actually by the registrations, because the registration starts by a particular person and the returns filing.
That was the jurisdiction where the registration is made.
No, registration given assessment has been done. But the assessment starts with the filing of the returns.
This aspect of, let us see.
Here, your lordship, I may be permitted to show 2 to 3 dates, your lordship, when we have stated the proceeding fast. So this may not arise.
So please, prepare the notes on that and let us see that we have to decide that the data, it is not for this case, but for all time to come, one should know that.
We'll come back to your lordships that when a particular proceeding is initiated.
Correct, we want it.
And whether it is on the issue
Because
of
there are two things. One is the initiation. One is the contemplation. And the third one is the registration. I mean, still thinking about the civil perspective.
your lordship are correct.
Presentation of a claim does not tantamount to initiation of the proceedings, nor would culminate into the registration of the case.
If I
There are various facets in this regard. That is what we wanted. Because here the date is very much relevant for the
and
purpose of
here, Lord, what has happened? That's only at the cost of repetition. I'm sorry, my lord, it's already getting late. If you'll actually just give me 5 minutes. What has happened, my lord, in this particular case? 2019, what has happened? They have summoned
detention of a hungry person.
I'm sorry. It's a criminal offense, my lord. It's both. I'm sorry, my lord. I have not seen the times. I'm sorry. And it's also dangerous on my part not to submit anything because these are very dangerous periods, my lord.
No, come ready. No, ready on that. Let us see. On a different.
Some interim,
Some
some interim protection, my lord, in the meantime.
Center, TGS.
There's a
They don't proceed for the time. We are fixing this matter in the next week. Anytime, 7, 8, whatever.
8.
At least I'll try to satisfy your lordship with assistance of my learned senior man also.
Yes.
Nothing.
Maybe pardon me, Lord. Item 7 that habeas corpus matter, Lord. I informed to the non-counsel for the petitioner. He has some difficulties in, he is in hospital. He has requested for next week.
So I have this no second. Your lordship may pardon me. Your lordship may pardon me. Item number 40. I'm sorry. Item number 14. So may, instead of 8th, may I pray for 17th, subject to your lordship can confirm. In item number 14, instead of 8th, may I pray for 17th month, 17th of this month. 17th. Greatly obtained.
16.
Lordship, I may be please permitted to appear online, Lordship.
Yes.
Lordship, in this case, I am challenging the ex parte order passed by the Service Tax Department, Lordship. The show cause notices and personal hearing notices were not served on me. Therefore, I did not participate in the adjudication proceedings to defend my allegations, Lordship. In the similar circumstances, Lordship has passed the order. May I be please permitted to my colleague submit the copy of the order, Lordship.
Yes.
If Lordship please to grant one opportunity, I will go and defend my case before the adjudicating authority, Lordship. My service is covered under the negative list, Lordship. During the subject period, the petitioner has not conducted any business in the
Case is that he has not undertaken any services in the state of Orissa.
he is not exempted, but the case is that he has not undertaken any services in Odisha. That has to be waived. This order is so what do you want? No, this is a factual issue, my lord, that has to be verified whether the service has been. What?
This is, this was some. Yes, sir.
I have seen the only humble submission. That only the one what has been mentioned in the order that he has undertaken government services to government authorities that will not come here. That is the only observation which your lordship may do.
Fact.
Yes, my lord.
His client is exempted from paying it as it is engaged in common. This is
Madam, my lord,
subject to satisfaction of authority. Is it that it is his submission?
my lord.
It is his submission.
You are whatever services to the government authority.
No,
No, my lord, because
Then why you are giving this without any?
my lord, the impugned order which was issued against me, because of that, we want the prayer is
You
set
made
aside
the
of this.
connections and then everything has gone.
That has to be corrected. To that extent, that has to be corrected.
He claimed exemption because he undertook certain works with the government.
My lord, the order which was issued against us is a impugned order. So because
Sir, when you are relying on this that pass the similar order, then it is not factually incorrect order. So certain facts which is recorded therein is not eminently present in the instant case.
my lord, only that paragraph is if
What then you ought to have said that.
Lordship, may I please, Lordship, in this case also,
what in the my lord, in this case the impugned order and
getting authority for first consideration, Lordship. I'm denied the opportunity to defend my allegations, Lordship, at the adjudication stage.
attachment order also issued against us. my lord.
So
If you don't appear,
then what can be done? How they can be put at fault? If the notices were given, you chose not to appear, then what fault?
My lord, we had not
Not-
received the proposed notice.
That is what is there.
Lordship, the
Show us
Showcase
from the
notice.
document, show us from the document that they received the notices.
To that extent, there is
Take
nothing-
instructions and come back on the next date. Give us. They say that they never received any notice. Please come and show that it is there.
Yes, Lordship.
The mode of serving a notice under the rules you have exhausted.
I will take instruction.
Take instruction, come on the next date.
I enclosed the order
Whether
copy.
he is
I enclosed the order
whether he
copy.
is available on 9th.
My lord, let me ask him the date in your-
We are fixing this matter on 9th. If you want to appear, appear.
Right.
9th.
Item number 16.
May I continue? That's it. This matter relates to reassessment proceeding under the Income Tax Act. That's it. Earlier, your lordship, this is the second round of litigation, your lordship. Earlier, division bench of this honorable court, your lordship, has quashed the reassessment proceeding. And your lordship, let's remit the matter back to the assessing officer for trace hearing. And lordships directed to pass an order in accordance with law. The expression in accordance with law. Your lordship, after a period of 11 months from the date of passing of this order, your lordship, now the assessing officer initiated, your lordship, the word initiated, the fresh assessment proceedings invoking amended provisions of the Act, Your Lordship, which came into effect from 1st September 2024. Because challenges is on the ground that this impugned initiation of this proceeding, Your Lordship, the assessment proceeding, is barred by statutory monetary limitations, Your Lordship.
Statutory, monetary,
Limitations, Your monetary limitations.
monetary limitations.
Yes, Your Lord.
So what is the demand?
Your Lordship, alleged escapement, Your Lordship, is 34,99,247.
Correct.
Your Lord's provision of section 149(1) states, Your Lord, no notice under section 148 shall be issued for the relevant assessment year if 3 years and 3 months have been elapsed from the end of the relevant assessment year, unless the assessing officer has in possession books of accounts or other documents or evidence which relates to any transactions or entries, that income chargeable to tax has escaped income, Your Lordships, amount to 50 lakh or more. Because here is a case, they are admittedly.
So they are below 50 lakhs.
Yes.
Is what you say.
In this case, this assessment was again, the notice was issued after the direction of this Honorable High Court.
But this, what he says is that there cannot be any question of further notice to be issued, a fresh notice, because it was quashed and it was he says that remitted to the authorities to decide afresh. Means on the basis of the notice which was already there, it was an order which was quashed. So there was no occasion to go for a fresh notice. You should continue with that.
That has been.
No, he says the fresh notice was given, invoking the amended provision. If I correctly understood what he says. It is not that continuance of the old proceeding. It is what you have initiated a new proceeding.
No, Lordship. Page now, annexure 2, it has been written letter or order under
Annexure
138
5,
in view of any
Mr.
direction of
Counsel.
Honorable Court.
Mr. Counsel, Annexure 4, Para 6.
Yes.
Page 36.
Lordship. Yeah, the court remitted the matter to the
Please,
considering the contention raised by the learned counsel for the parties and without expressing any opinion on the merit of the case. Since it is S.C. Mark is learned understanding counsel for the revenue, there is fair submission that the opportunity of hearing has not been given to the proceeding.
Will continue and be hearing.
No.
No, this was an order of assessment is set aside. Notice was not set aside. The notice was not set aside. Their order. Because
subsequent notice given to you.
Yes, Your Lordship.
Citing this pecuniary limit.
No, I'm not.
You are not brought to the notice of the assessing authority who is proceeding now.
No, Lordship, I'm not on that grounds, Your Lordship, I have not replied. I'm challenging to the alleged escaping income and to request to drop this proceedings. At page 38.
So on merits you participate.
Yes, even Your Lordship will appreciate me, Lords. On alleged escaping income, Your Lordship, the Honorable Delhi High Court, Your Lordship, in similar identical circumstances, Your Lordship, passed this proceeding.
Where is the fresh notice given?
Your lordship, first notice, your lordship, PS 28, my lords.
Hmm? And this was dated 20th of
March.
March 2025.
Yes. On that date, your lordships amended provisions commencing operations.
Is what you have to say. And how you can initiate a
Notice 148 1, where it has been written, being agreed with the order and passing on the facts. Unable to see mail, we find a writ petition filed before this honorable.
Correct. But it says an
So,
appropriate, you are requested to submit the following details and documents for further proceedings. And then you are giving them an opportunity to file a reply and all everything.
After getting the direction from the Honorable High Court,
It was not. Whatever was available with you on the date when this particular proceeding, the order was passed, you could have proceeded on that basis.
Let me take instruction.
If you have the jurisdiction, then only you can proceed. If you have the jurisdiction, then only you can proceed. If it is 34 lakhs, the statute itself bars you from exercising that power. Even if this court
He says because of the order of the High Court, I can proceed.
Only that thing.
in spite of that, you can.
But the subsequent, that's why he was putting emphasis on the word in accordance with law. Why he was putting an emphasis says.
The first date will be taken into consideration if the first petition has been issued. That will be taken into consideration on that.
Whatever.
Let me take instruction in this matter.
Where is that provision which says the 50 lakhs?
149 1, your lordship.
Sure.
I read.
No. Where is the amending law, this Finance Act 2024?
Your lordship, substituted by Finance Act number 2, 2020, with effect of.
Where is that?
Footnote, your lordship.
No. Probably you do not get what I am trying to get it. That was the earlier section, which is substituted by way of an amendment.
Yes, ma'am.
In this manner. There must be an amending act, which is the Finance number 2, Act 2024. Where is that act? Finance number 2 Act. I want that.
Lordship, kindly have attached to section 152, subsection 4. Lordship. Kindly have attached.
Yes. Subsection?
4. Lordship.
Yes.
where in a case other than that covered under subsection 3, a notice under section 148 has been issued on or an order under section 1 clause D of section.
So there's a saving clause, so it will be guided by the old act.
Yes. But that,
So that saving is there, so it will not lapse as you said.
yes. But that, Your Lordship, I am relying on the judgment of order of Honorable Allahabad High Court, Your Lordship, recent order. That's kindly.
Justice Saraf.
Ranjan, just Honorable Justice Ranjan.
What? What is this? This order on consent, sir? Is it a law binding on the court or a bench? Is an order on concession? Then you are relying on a judgment. Answer us. What is the effect of subsection 4 of section 152?
Yes, ma'am.
Because they say that it is not a fresh notice which they have given. It is really a continuance of the notice. Then the barrier of 50 lakhs, whether it will be attracted or not attracted. Show us.
That's what my humble
concession is about it. Yes?
My humble submission, Your Lordship, before Your Lordship is there. My lords, nowhere Your Lordships in the order of this Honorable Court, Your Lordship has prevented the assessing officer to initiate the proceedings prior to September 2024. Number one. Your Lordships, he himself, Your Lordship.
Sir, first and foremost, the hurdle is that whether this notice is the initiation of a fresh proceeding or it is simply continuance of the already instituted proceedings.
My humble submission here on that respect.
Yes.
He himself, Your Lordships, relying on 148 subclause 1, because he has not relying 148 capital A subclause B, because this is a show cause notice issued under the amended provisions of that, Your Lordship.
No, it can't be.
Yes, my Lord.
Where is?
28.
Yes,
28.
Where? Page 28, I am looking at it.
Yes, Lordship, can have
So,
a notice under clause 1.
That is a caption. Then what about the first paragraph? First paragraph, because unamended 148, 149 capital A, there is no provision of 148 capital A. If you look at it, no, there is already there was an earlier provision also 148 capital A.
Yes, Your Lordship, but my humble submission, Lords,
So that notice is under the old provision.
Yes, Your Lordship, under the one, but that notice, Your Lordship, has been already passed by this Honorable Court.
This is not a cost one. I was looking at the order. It is what the order was cost. But there is one ambiguity. The notice was cost, but I do not think it was not cost actually. Cannot be said to be a good in eye of law.
Even Your Lordship,
What is the interpretation of this order? Sure, where is the order?
Order 36 minutes. Yes, 36.
Correct. Paragraph 6 is the important one. Look, considering the contentions and without expressing any opinion on the merit, since such and such, learned senior standing counsel for the revenue made a fair submission, that opportunity of hearing was not given to the petitioner. the order dated such and such passed by the authority under section 148 AD cannot be sustained in eye of law, and the issuance of the consequential notice under section 148 of the Income Tax Act, Annexure 2 also cannot be sustained. This is what is the 2-1. So the notice under section 148A was also already given. Is it? 148 is a I would say the stage of 148. Correct? So 148 stage gone, but 148A also there, they initiated. That was retained. And then say remit the matter to very same authority to hear afresh.
Well, so in a constitutional law, your
So-
law is not
Going back to 148A stage.
Yes, please.
So where is the difficulty? Because it says this court, then what is the meaning of this sentence? This court remits the matter to very same authority to hear afresh. What? By giving opportunity of hearing. What are he to hear afresh? To initiate a fresh proceeding, I can understand. To hear afresh means at this stage of 148A.
However, your lordship,
So they have given a stage of 148A.
your lordship, greatest respect, my lords. Now, your lordship, he is initiating the proceeding, your lordship, in the.
It's not an initiation, it's a continuance of the proceedings.
Notice, your lordship. It's a show cause notice, your lordship.
This is not a show cause notice.
It's 148A1 is show cause, your lordship. My lordship,
That is what is already there. He simply intimated. Can't you visualize? 148A was invoked. Thereafter, 148 was invoked without giving an opportunity of hearing anything. Principle of natural justice not followed. And then it culminated into an order.
Yes.
Correct? The order was challenged. The court finds that yes, they conceded. Rather, they conceded. You did not won. Actually, they conceded. Yes, there was no opportunity given. So the order, notice 148 or order passed in 148 were quashed. And the court says that you go again at 148A because that opportunity was not given to you. Now they have reflected in the notice that this is what the High Court has said. This is what this is the thing. Since you invite or you wanted a hearing opportunity, please give your reply.
But he issued a show cause notice, your lordship, under the amended provisions and asked for the documents, your lordship. I have replied. Then
Because he wanted, the court has said that principle of natural justice was not followed, means adequate opportunity to defend was not extended to you. So he wanted to give you all opportunity to contest or defend. So by virtue of filing any documents, by giving your pleadings, everything is inviting you to file it.
Lordship, he issued this notice under section 148A1.
My view is different. Because the entire notice has to be read in that perspective. Sorry, the notice has to be read in that perspective. Yeah, we can't accept it. Sorry, we can't. No. You will ask for an adjournment, I know.
Yes,
but yes, I know you will ask for an adjournment. But sorry. Yeah, that's true. Order is also passed on 148A. Huh?
Next week. And then some merits or similar identical supplements. This is the issue relating to a supplier. A supplier has I have purchased. It's a similar cases because
It is at the stage of a show cause. Go and take all such plea. The authorities have not finally arrived at the decision. Now they have to issue a notice under section 148. Is it? You can take all the plea in that particular show cause notice. Go.
Next week.
No. Because I anticipated the moment we showed our dissent, immediately the adjournment. No, we'll pass. No, brother. No, dispose of it. Well. Yes.
You want detailed order or you want to pursue the matter?
Yes. It's a special case of these cases where the High Court remitted the matter. That's a special facts.
Go and pursue the matter there, or you want detailed order?
That's the detailed order.
Detailed order. Yes. We'll pass. Yes.
Done. Item 17.
Write it. These are this come.
This matter related to RC cancellation is offered by
All
of
Item 1, 2, and 5 I am appearing. We have for these.
give a memo of appearances.
Yeah. It has been called.
lots of
For no good reasons.
Your lordship lost very bad.
Yes.
Item 18.
Traditional law is a educational foundation law, the trust. And it has come.
Is the
petitioner law is a trust law, educational trust.
private educational or a public educational?
Private educational trust. And they are allowed amenable to certain benefits under the Income Tax Act. Here, the allegation against the trust is that for the assessment year 21-22, there has been some escapement of income. And therefore, a proceeding under 148 was initiated by giving me a notice under 148 capital A. The main ground, my lord, is one of the main grounds, my lord, is as your lordship knows, that section 11 of the Income Tax Act provides for accumulation of excess money spent or accumulated beyond 85% for a period of initially it was 10 years, now it is 5 years. And my lord, there were prior to this 21-22, it was said that or for the subsequent year, it can be spilled over. So, but there has to be an utilization within 5 years or for the subsequent year, within the subsequent year, otherwise it will be put to tax. Here, my lord, for the assessment year 15-16, a surplus of 14 crores was accumulating. I filed a Form 10 notice, which is a mandatory requirement, declaring, my lord, that I'd be utilizing this amount within a period of such and such period.
The extended period according to you.
So that particular accumulation was utilized in the 6th period, and I filed my returns for the assessment year 22-23. What has unfortunately happened, my lord, is the officer, my lord, he loses sight of this particular committed provision under section 11C3, which says that this can be spilled over to the subsequent year also, if it is after 5 years or to the subsequent year. Then he charges me the entire 14 crores, reduced by the amount which I have spent, not 13 crores amount, he puts that to tax. The second difficulty, my lord, is that there is an allegation that there were certain fake bank or undisclosed bank accounts. Unfortunately, my lord, this particular proceeding was initiated on the 7th of March. And even though, my lord, the limitation was till 2027, because 5 years, 3 months is the limitation for the end of the financial year, to initiate a proceeding and complete it within 148. Within 21 days, it was completed. Now, I was asked for certain information. So I gave whatever information was available. But unfortunately, this was completed on 1/4/2024. And there were certain informations which came from the bank in the month of June, which could not be produced before the authorities, for which another 96 lakhs amount was not added. So, sorry, 92 crores, I'm sorry, 92 crores, I stand corrected. 92 crores was added, Milods. Then, Milods, another 35 lakhs amount from another bank, for which this particular information could not be gathered. So far, the first submission, Lord, about this accumulation is concerned. Lord, my humble submission, Lord, that this is a case, Lord, that should be reconsidered by the authority concerned, Lord, before he comes up to an opinion that there has been an escapement of assessment and there should be a 148 proceeding under section 148. So to demonstrate that, Lord, I'll just take your lordships to section 11(3)(c). Before that, 11(2)(a) speaks of 5 years. The lordship would kindly turn to section 11(3)(c). Lordship got it? Is not utilized for the purpose for which it is so accumulated or set apart during the period referred to in clause A or subsection of that section, that means section 2. Then, there's an asterisk there. If you can kindly see the footnote. This word which was omitted was or in the year, or in the year immediately following the expiry thereof. So in essence, Lord, I get 6 years, 5 + 1, to utilize this amount before it is put to tax. Now, this particular omission, Lord, was with effect to 1/4/2023. So we are dealing with assessment year, Lord, 21-22. So this particular provision, and if your lordship would see that order, Lord, unfortunately, Lord, he stopped short with that particular asterisk. The lordship would kindly see the order, impugned orders, and if it will, at page 103. And if your lordship would kindly turn to page 107 of the impugned order. What you got it?
Yes.
Is not utilized. He quotes 11(3)(c). He stops with 83, that asterisk. But he doesn't, consider that this or in the year immediately following the expiry thereof, which was, my lord, very much there in that relevant assessment year, my lord, which came to be omitted subsequently, my lord, with effect of 1/4/2023. And if your lordship would see the utilization, which I've
we are not concerned, is on the face of it when this applicability of section 11(3)(c).
Only 11(3)(c) is not the matter.
I'll come to the desk. This is one of the allegations. No? Yeah. The second allegation, my lord, is about, my lord, this. If your lordship could see the conclusion, based on the available records and after considering the So since this is a major chunk, I was only praying, Lord, let him apply his mind and also to the subsequent, my Lord, bank statements and
Evidence, further evidence.
Further
which you post.
right,
order.
right, no. And this
You
90
want to produce before.
produce, and it was, I have already also annexed it. This 92 crores 59,60,000, Lord. The Lordship would kindly turn to Annexure 16. This, he says, is a deposit from Union Bank of India. If your Lordship would kindly turn to Annexure 16 at page 129.
Yes.
There they say, my lords, with reference to your request number so and so regarding the term deposit for the financial year 2021, closing in March 2021, held in our branch, as informed by you regarding IT notice, where it is mentioned under SFT 005, that is the account number, that time deposit of amounting to 92 crores 59,60,000 is reported wrongly. We clarify that our HO's tax cell has done the rectification entry on 16/6/2025 in the form of number 61A, transaction ID number so and so is reported to PAN number so and so, provisional receipt of statement and screenshot of the rectification attached for your reference. And if your Lordship would just turn over the page, this was also posted in the website of the Income Tax Department by the bank itself. That's page 130.
Yes.
Page 130, if your Lordship would see, Union Bank posted this, my lords, on 16/6/2025. It was uploaded, and the statement of financial transaction. Reported period, which was uploaded in the portal of the is 2021, and I've shown the contents of the letter. Then, my lord, there was another entry so far as the HDFC Bank is concerned. That, my lord, amounts to, my lords, 35,44,446. And if your Lordship would kindly turn to
Now they are contemplating to issue a notice under section 140.
True, my lord. But
so let them go, and you can rely upon all the documents.
my lord,
There is no
your
difficulty.
Lordship would appreciate, my lords. After GK and Drive Shop, my lord, of the Supreme Court was a judge-made law to give a pre-148 notice. Thereafter, my lord, with the amendment, as in the previous case, your Lordship would see that by a series of amendment in 2022, they introduced 148(1)A, B, A 148 A
and B,
A, B to D.
Hmm.
So that gives a whole range, and a natural justice was also given because the department as well as the CBDT considered that before putting these assessees to a harsh reassessment proceeding where the assessments have already been completed or the returns have already been accepted, let us give them a chance. So, my lord, they went beyond GK and Drive Shop and they statutorily incorporated this. And that, my lord, with effect from 2024, as your Lordship have also seen, it was amended, but 148A was retained. 148A, 148B, 2, 148.3. So all these safeguards are there, my lord, that before you put me.
I understand. These are the safeguards, but they are not going to take immediate coercive steps against you because it is really a pre-148 stage. So now after that, if they arrived at the finding, these are mere a prima facie or a tentative findings, which may lead to issuance of a notice under section 148. If they issue a notice, then an opportunity to contest is automatically ingrained.
Your Lordship.
You can take all such plea. You can also rely on that. You can do it because if you shut down at this stage.
No, I'm not requesting or praying for a shutdown. the only limited prayer, my lord, let him reconsider it.
What for? Then we'll have to say that this particular order
Because
is absolutely perverse.
No,
perverse.
need not, because your lordship may only see that this order was passed on the month of April, 1/4/2024. Right. I get this information at the lowest, my lord. I get this information, the bank intimates it on 24th of June 2025, which material amounts to a substantial amount.
Absolutely. I'm just saying, so that
if
opportunity
he
you will definitely have.
True, man.
You will have that
No,
opportunity.
if it can be, Lord, nipped at the bud by the authorities himself, if he considers that this is a fit case which should not go into for a 148 slot, but I need not be put into the rigors of 148 now. My lord, now your lordship would in the present setup, my lord, it will be all, my lord, a faceless assessment. Then, my lord, what they consider or what they do not consider, my lord, I'll not be in a position beyond uploading my defense. And true, my lords, what this has happened, my lord, the second difficulty would be that this particular order, my lord, was my lord, given with the prior approval of the Joint Commissioner, who is a very high-ranking officer, my lord. So once it goes, my lord, with his recommendation, then, my lords, it will be, my lord, treated with a pinch of salt, whatever be my defense.
No.
My lord, it has happened, my lord. No. Unfortunately, my lord, it has
It will
happened.
definitely not.
And your lordship would appreciate.
Definitely not.
And your lordship would appreciate the manner in which this order is passed. He, my lord, initiates the proceeding. My lord, he says, if your lordship would kindly turn to page 103. The order is dated 1/4/2025. He says, my lord, the prior approval was taken on 1/4/2025. So what is the application of mine, my lord? Even if your lordship would see it from that angle, my lord, because all these safeguards are there, because the higher authority's prior approval is necessary, because there be some application of mine by the higher authority to certify that this is a fit case to go for 140. If your lordship would
It all
kindly
depends upon the I would say the potentiality of a person. One can take a decision in 30 seconds, one can take a decision in 3 hours. So what is the difficulty?
And your lordship would see the plight of this particular petitioner slapped with a demand of 109 crores.
But he's not going to take a coercive steps at this stage. It is simply a prima facie or a tentative opinion.
But if
leading to issues of notice under section 1.
I bow down.
That's all.
I bow down, my lord.
No problem.
But if your lordship would, my lord, if he is satisfied, or if I am able
It's not a final opinion which he has expressed, nor can.
But with the stamp of approval of the higher authority, my lord.
Hard ways. Take another case of arbitration and conciliation. This Chief Justice of the High Court appoints the arbitrator.
No, that is on the administrative side.
No, judicial. After SBP is a judicial order. Concon was earlier. These were the administrative. Now it's a judicial order. And even thereafter, under section 17, the arbitrator is competent to rule its jurisdiction and can say that I have no jurisdiction to decide.
That is my
Where is the difficulty?
That is by the
so these authorities, merely Joint Commissioner has sanctioned, that does not mean that he will not go into the
maybe
I think intricacies of all these facts. He may ultimately say it's not a.
No, maybe, my lord.
We can make an observations in this regard. Your apprehension can be taken care of.
Maybe I could not.
Will say that is the independent decision that would be taken.
No, maybe, my lord, I could not put my point across to your lordships. What I meant to say is, this approval by a higher authority has some sanctity in law.
Sir, approval to what?
Approval because to go through whether this has been done in the right manner or not.
What to go through it is done in the right manner?
Because
please tell me.
The basis on which this particular conclusion was, my lord,
true or not? The conclusion was, again, that's why I say this approval can be said to be an approval to arrive at the prima facie or a tentative finding.
True, my lord, but
for initiation of a proceeding under section 148, nothing more than that.
Obliged, my lord. But it can't be a mechanical exercise.
No, it's not a mechanical exercise.
Your lordship will kindly see, my lord. I have, my lord, beseech you.
That is a good case, but
my lord, my fervent prayer. was applicable to
That
me.
was the only submissions which to some extent swayed
No, no.
us, but
And 14 crores.
because all other materials on merit
And
you wanted
No, I
to
don't-
rely upon was post.
But your lordship,
So-
this particular entry, my lord, just to place it.
Whatever the now interpretation or perceivement of those entries is within the domain of those
But your lordship,
authorities. Let them decide. The court cannot make a roving inquiry in that regard.
Crores,
No.
not 14 crores, your lordship. For
That's not a demand.
It's not a demand, but
So
But
why
it's a
you are apprehensive?
But it's a liability, my lord.
Whatever
And
is
your lordship,
is a prima facie liability, but it does not mean that this liability attained finality.
But your lordship would appreciate
It has to culminate into an order under section 148.
But as a writ court, my lord, your lordship would
No,
be-
writ court.
I do understand, my lord, the principles of equity will not, my lord, apply in a taxation statute. But prima facie, my lord, all that I'm praying, my lord, that
We will say that none of the findings would have any bearing, nor the authority who will initiate the proceeding 148 will be swayed by the fact that the Joint Commissioner of the Income Tax has given a permission or has given a nod to that.
I bow down.
Independently, everything has to be decided in accordance.
Fervently, my humble prayer would be, my lord, before my lord exposing me to this 148, my lord, just give me one chance.
No.
The lordship may put me to terms within a month's time. Let him complete it because
No.
the limitation, my lord, is there till 2027, my lord. My lord, for a moment, my lord, I'll not take any time. I'll appear before him with all my submissions, with all my accounts. Let him apply his mind.
It will be the clear case of a non-consideration of evidence.
Further inquiry, my lord, please get back to me. I'll produce either in law or in facts. I give him all the papers, and my present predicament, my lord, is because the banks, my lord, they did not come up with the appropriate information, my lord. Even though they, my lord, uploaded the information, it was a bit too late, where the orders have already been passed. So, my lord, any day next week, my lord, if your lordship would permit me, I'll appear. I'll try to convince him, my lord, and let him complete this in another 4 weeks' time, my lord. I'll not seek for a day's adjournment. But before, my lord, please, lordship, before exposing me to the rigors of 148, my lord, let me be given a chance. Let him reappreciate this, my lord, these entries in my books of accounts, the statements which have been given by the banks, which is now available in this portal, my lord. Let him, my lord, consider it.
Yes.
At least, your lordship, kindly give me some breathing space to appear before him, Lord, and let him take a decision. And then, Lord, he can pass this order, Lord, after a month also, if he's not satisfied with my explanations or with the material sent by the bank.
Yes.
And legally, my lord, the 14 crores, my lord, I've already shown it to your lordships. Besides that, 92 some odd crores, my lord, Union Bank says, my lord, they have already deleted that entry. And, my lord, another 35 lakhs, my lord, the HDFC Bank, my lord, they say that has gone to another institution that is the Trident Academy, and that has also been settled by me, my lord, on me, my lord. So, my lord, at least, my lord, I can demonstrate before your lordship that after a major portion, my lords, I have an answer for him to appreciate my submissions, and my lord to delete that entry if he is convinced, and do not expose me to 148. And in spite of that, he suggests, my lord, for 109 crores income, my lord.
Yes. Thank you.
My last attempt and my last prayer, my lord.
What is your judgment? You have already taken. And the notice stage.
My last humble my last, Lord, humble submission to be, Lord, one more chance. I know that this is not a final thing. I agree with your lordship, but Lord, to put me into that with Lord 148 proceeding, Lord, let me be given a chance, Lord, to come up with all those information.
That's all.
Because on
the writ petitions are the writ petition is filed, assailing an order of the authority passed under section 148A within bracket 3 of the Income Tax Act 1961. Opining what is this? What? This is what is happening. Actually, this is like the order is present of the parties with commission.
But the appellant, it's before this appeal, challenging the order of the authority, Assistant Director Treasury, Municipal Letter 3/9/24, which is the order of honorable signatures, 4/9/24, where the authority has rejected my claim on the ground that the acquittal of the appellant was a benefit of doubt. Personally, I have a glance, and it's just page 75. That is the order of the authority. That of presence and inspection, page 76.
No, your demand was the back pages after the acquittal
Yes.
comes.
Yes, already.
Now, have you seen the latest judgment of the Supreme Court by Justice Nagaratna? Have you seen that? The right to claim back wages is not a absolute right.
No, not
It is,
absolute.
it is a discretion which is to be exercised.
But
And in that
discretion-
event, if the authority did not, then how you can go and ask for?
But the ground of my rejection was this. That is my ground of my rejection was. First, I'll see that. But why
Yes.
I am claiming
Yes,
my.
what is the ground for rejection?
Yes,
Let
that
me-
is benefit of doubt. That was
So
my.
means your proceeding, the proceeding initiated against you, I think it was a departmental proceeding which was initiated.
Criminal proceeding.
Criminal proceeding, so benefit of doubt.
Yes.
Obviously, now,
No, benefit of doubt is not there. That is my submission. Benefit of doubt is not there. That I will explain. And the honorable signatures also confirm that out.
this is GM Tang or a GS Tang judgment of the Supreme Court, which says honorable acquittal
Yes.
and the acquittal by.
That has been explained by the judgment rendered by Export. That is a RAMAN case. That particular the benefit of doubt that has been explained. How it is not applicable. May just giving the judgment. You can see. Para 25.
Read.
Yes. The expression like benefit of doubt and honorably acquitted used in judgments are not to be understood as magic incantations.
Correct.
A court of law will not be carried out by the mere use of such terminology. In the present case, the appellant.
But has to look into the substance thereof, whether it is a case of a honorable acquittal or it's a acquittal on the basis of a benefit of doubt.
That is the benefit of doubt is not there.
Who says that even in GS Tang it has been said?
That is the court. When I in the appeal miller, my acquittal is that is a clean acquittal. That is also my honors. This honorable High Court order also there that benefit doubt is the honorable doubt. Honorable acquittal.
I am again asking, sir, benefit of doubt or a honorable acquittal, both in both the cases, sir.
Yes.
Your right to claim a back wages, whether it is an absolute or sacrosanct right, tell me, that's the only question.
Yes,
you
sir.
are claiming for a back wages. Tell us.
Why I am claiming my right? That is my right, Lord. But my acquittal was
Forget about the observation of the single bench that he says the acquittal was benefit of doubt.
Yes.
Tell me your right to receive the back wages.
Yes, ma'am.
Straight away.
Yes. But I'll just explain the fact of the case, ma'am. Just. But I'm giving the debt check. May I read the debt check, Lord, so that I can appreciate my Lord. That is how.
Yes.
Yes. My debt check, Lord. I read the debt check. On 27/1/1988. The appellant was appointed as junior clerk in district treasury.
Yes, GM Tang was considered here.
Yes.
This Tang judgment was considered here. Yes.
On 27/11/2023, while he was continuing as a junior clerk in treasury office, Palada, a vigilance case by number Shonsho was initiated against him. Thereafter, he was suspended from service by the Directorate of Treasuries and Inspection of Obligation. On 19/5/17, having been proceeded with the vigilance case, since the vigilance case before the court of law research on cutout in clear case number 31447, the London court would have applying judicial mind in proper manner, found him guilty in the offense of and convictions patent was mentioned. On 2010-2017, after the commission of the past the Women's Court, he was dismissed from service. By his pleasure of But my lord's judgment was that is the my lord's asked the judgment that is also referred in this Ramlan's case. But
I said that the GM tank is,
yes. May I continue the lecture.
that is again, sir, these are the cases
Yes.
which are relatable so far as departmental proceeding, continuance of the departmental proceeding vis-a-vis the criminal proceeding.
Yes.
That those are the relatable. Here, your claim is the back wages.
Back wages. Okay,
Now,
we-
question is
back
that
wages-
whether the right to claim a back wages is a vested right or is not a vested right. It's a discretion of the employer or a discretion of a judge.
But discretion, but here, when the appellant has acquitted from all charges, there is no evidence, nothing that has been held by this whole court.
I am
Even appeal.
asking, sir, that's why I'm saying there are judgments galore which says that after the disciplinary proceeding ended and I was not found guilty,
Yes.
then I'm entitled to all the back wages.
Yes.
Supreme Court has deprecated that it's not a vested right.
But that doesn't.
It's not a vested right.
But in Canton care,
Sir, you were implicated in the criminal case.
Yes.
You were arrested or not?
Yes, sir. Yes, sir.
More than 48 hours.
Yes.
So
Suspended.
deemed suspension.
Yes, sir.
You must be getting a subsistence allowance during the period of suspension.
That is
That 50% initially, then 75%. You got it.
Thereafter, I was acquitted.
Now thereafter you were acquitted. The disciplinary proceeding also, was it initiated or not initiated?
They allowed.
They did not.
They allowed me join there also.
Oh, has to.
They have to allow join there. After that,
You were under suspension. That means you are not under termination.
yes. Initially, I was suspended.
You are all along
Yes,
suspended.
Thereafter dismissed. Again,
How?
they started me sorry after the.
How they can dismiss you? There was no proceeding initiated.
They dismissed. And it's, yes, they dismissed from service. The blood kind have a glass to page 30.
My lord,
Page 30.
after the criminal proceeding ended in acquittal,
Is reinstated. Suspension order was revoked and he was allowed to join.
Claimed by acquaintance. That having been turned out, he approached the Honorable Writ Court. Honorable Writ Court, relying on Section 91 of Police Service Code, there is a bar under Section Rule 91 of Police Service Code. You will also kindly see that provision. Relying on that only, the Honorable Single Judge rejected. So he cannot wriggle out from this statutory provision.
No, what is this?
That has been taken OJ
This
service.
book must be here. What is this? OJ? Service code. Service code.
And that has been taken note of by the Honorable Civil Judge in the judgment.
But the main factor you have decided that basing on the order of the
It
government.
has no part 1 or part 2. No.
91.
In Bengal, the West Bengal Service Code has 2 parts. Part 1 and part 2. Rule
91. Authority competent to order the reinstatements are considered and make a specific order.
What is this?
also-
Authority competent to order the reinstatement shall consider and make a specific order.
Yes, ma'am. There also can come to 3. 91. Okay. In the case of dismissal, removal or compulsory term, the government service is not completely exonerated of the charges in service. It shall be open to the competent authority to decide not to allow.
No, it is coming under B. It's coming under B.
Also, yeah.
Is coming under in case of a suspension.
Government servant not exonerated of the charges fully is reinstated in service. He may be allowed subsistence allowance only for the period of suspension and Demolition under Rule 19. Also, 91(2) also may be relevant, where such competent authority holds that the government servant has been fully exonerated, or in the case of suspension that it was wholly unjustified, the government servant shall be given the full pay. Where he is fully exonerated,
Yes.
full pay to which he would have been entitled had he not been dismissed.
No, this is. The difficulties. What about sub-rule 2
Sub-rule 2.
of Rule 91? So read
91(3).
91
91.
2. 91 2.
Yes, madam. Yes, I was placing them. Where such competent authority holds that the government servant has been fully exonerated, or in the case of suspension, that it was
Now
wholly
the question is fully exonerated is akin to an honorable the acquittal, or the fully exonerated mean something something above the acquittal for adequate evidence or on a benefit of doubt.
That's what my submission is. That since he has been acquitted, you also make kindly see he has endorsed the judgment entered by in criminal appeals by the Honorable another single judge, that you also will find at page 64
at page 64 of the brief. Criminal appeal judgment.
Sub-rule 3 is it attracted with this case?
No.
Sub-rule 3.
Which learned single judge has
91 thing, 90.
And 3, which learned single judge has referred to.
Yes.
Without taking note of sub-rule 2.
Yes.
Sub-rule 3 has 2 parts. Sub-rule 3 has 2 parts. It will attract. It will attract in the case of dismissal and when a government servant is not completely ignorant.
Yes. Yes.
So in this case, he is completely exonerated.
Your Lordship, that's what I was placing, Your Lordship, from the judgment. It is not complete exoneration. That's what my submission is. It is not complete exoneration, which is evident from the judgment itself.
If we take this judgment of Honorable Supreme Court, Honorable Supreme Court has analyzed this at page 15, effect of acquittal, and their lordships have analyzed the factual position on criminal proceeding.
You put that if Your Lordship.
This clean acquittal.
That's what I'm saying, honorable acquittal or something of that. That
Put
was.
forth the judgment of criminal court.
Criminal court judgment is there. That's what I was placing.
Where is
Page 64, relevant portion, my lord.
Yes, 64.
64?
Yes.
Yes. Para 17, towards the bottom, my lord.
We put that the page 63 made it, last part. That will be can be
You of the
can
following
the
discussions when
I'm sorry,
the
Page
prosecution
64.
did not successfully
Let's
establish the
64.
defendant's authority by the appellant beyond all reasonable doubt, the acceptance of bribe money by the appellant and sovereignty of the right and subordination of the appellant is a doubtful future. And moreover, the defense belief put forth by the appellant has been established that the permanence of probability it would not be even justified to hold the appeal. Yes. It is doubtful.
Continue.
Accordingly, criminal appeal succeeds and is allowed the interim judgment of unreasonable judgment.
All reasonable doubts.
Observations which are invented
He seeks that we recognize Government servant to undertake for pay and allowances from the date he assumes the charge. So he instantly
Why the entire judgment is not quoted here of the apex court, of the appellate court?
Just the page motion is.
Oh.
forward so long when it is said by that which is present. The period then when you are in a first position. Alright? If you justify it because it is not an abnormal and plus it is that in the case of its own conduct.
Doubtful so far as recovery. That is not.
That is it. So far as recovery, yes.
What is doubtful? Doubtful is with respect
Doubtful related to
Yes.
claim of bribe and recovery thereof.
There was no evidence which was adduced.
Yes, there was no evidence.
Yeah. And even a political
Prosecution
leader
failed to
who alleges, he also
substantiate the charges.
So
does the reverse.
May read once again. That conclusion portion only. In view of the following discussions, when the prosecution has not successfully established.
Correct. This
the
is very
demand
important. Correct. This is demand.
Yes, madam.
Then coming out of certain currency notes from the pocket that the appellate court says is a doubtful
Yes,
scenario. First thing is establishment that he demanded the bribe,
yes.
and that was not established at all. That's the offense.
My entire,
Recovery of currency is the consequences.
my entire endeavor is to persuade your lordship to come to a conclusion.
What is the meaning of the word fully exonerated? I do not know. Partly or fully, I do not know. In a criminal proceeding, what is this? I can understand if there are five, the penal provisions which were included. One is grievous, another is very petty or a menial one. The court found that the menial offense has been created, but there was no major. Then in that event, if the court comes to a finding and it acquitted him, compounding, then in that event, you can say it is not fully exonerated.
But law requires 91, set language 91.
Please look at it. 91.2.
Yes, ma'am.
91.2, you are bound.
We are not concerned with 91.
I'm again saying, please look at 91.2. That entitles him to have the full pay.
Where such competent
If you
servant has been
criminal appeal order, if you read this criminal judgment order that prosecution failed to establish its case, then it will directly come within the fold of sub-rule 2.
Let me
Please read sub-rule 2.
Where such competent authority holds that the government servant has been fully exonerated, or in the case of suspension, you are not concerned with this.
No, this is the case of his case of a suspension. He was under suspension.
Thereafter, once he was held guilty and was sentenced,
or the termination
dismissed.
Okay.
In the criminal appeal, he was
Subsequent. Yes.
but he was dismissed from service. So
Correct.
that is why
So termination, suspension, both.
suspension
Subsection sub-rule 2.
sub-rule, where such competent authority holds that the government servant has been fully exonerated, or in the case of suspension, that it was wholly unjustified. We are not required to. The government servant shall be given the full pay to which he would have been entitled had he not been dismissed, removed, compulsory retired, or suspended, as the case may be, together with any allowances to which he was in receipt to his receipt prior to his dismissal, removal, and suspension.
Correct.
So once he is fully exonerated, he is entitled to his pay.
That is what I'm
That
saying. And then sub-rule 3 has to be read in that
Yes,
way. Please look at it.
Sub-rule 3. 3A. In the case of dismissal, removal, and compulsory retirement, when a government servant who is not completely exonerated of the charges is reinstated in service, it shall be open to the competent authority to decide not to allow any pay or allowances to him. So
Now
it
he
is
is
coming under the
completely
domain of the authority.
Now he is completely exonerated by count.
That is up to your lordship to hold.
No, it has to be.
Appellate court's order. Appellate court's judgment to see.
The judgment according to exactly on the point.
He is discharged of all charges. He is acquitted of all charges. That is what the language is of this court. In appeal, criminal appeal.
Criminal appeal.
Huh.
If he has been acquitted, but
No. You read.
but since the prosecution failed to substantiate the charges,
Then thereafter the conclusion of this court.
Sorry.
Okay.
That's the judgment out in the case of acquittal. It is a direct judgment. Yeah.
My lord, I may be excused. I have got a single copy of a judgment which says that in case of acquittal, in the case of acquittal in criminal proceeding, then also you will not guilty. But I am sorry.
Somehow, Mr. Das, let it be very clear in this way. Ordinarily, normally, mere reinstatement after the dismissal of the criminal proceedings or a departmental proceedings initiated against him. The delinquent is not entitled to a back wages. that right is not an absolute or vested right. Please consider this. I am conscious, that's why I put that questions to him. It is within the discretion of the employer or the authority, or sometimes the court, after taking into consideration, can exercise such discretion in awarding that. But if there is a statutory rules, and the rule says that the back wages will be provided or given in a particular situation, then it accrued a legally enforceable right into them. It is a legally enforceable right because it is a rule which is framed by the government. So the government or its instrumentality cannot detract or cannot depart from there.
Yes.
You can't. The question is here the statutory provisions interpretation. If the right is created, it's a legal right which is created. Then in that event, if you have acted contrary to your own rules, then why not he is entitled to this forfeiture? That is what troubles us. We were not with him until you invited our attention to Rule 91.
The Rule 91 has been taken note of by the Honorable Civil Judge.
Well, I was not aware. I have not seen that.
That has been taken note of.
Yeah, that is what I
There is a note of sub-rule 3 inspection.
But sub-rule 2 is also very important.
This lordship has not taken consideration sub-rule 2.
Fully exonerated means what?
There lies the crux.
So lies the crux. I tell you, there may be a cases that previous provisions, serious provisions, and there is a fringe provisions of the IPC is there. So far as the grievous is concerned, could not be proved. But menial of physical assault not amounting to a grievous injury. Fine. When we impose, they impose the fine. Then you can say it's not fully exonerated. That is, he has been found guilty for some of the criminal offense. But if the acquittal comes saying that the prosecution has failed to prove
That
then it means, what does it mean? Fully exonerated?
That is the finding of the Honorable Civil Judge in the criminal appeal. Yes. I don't dispute that.
No, yes.
85. Yes, ma'am. I am holding that.
His lordship has extracted
91.
91, but omitted 2.
2. Yes, I'm conscious of that.
So, he was under the conception in mind that he was not completely exonerated.
No, 91 2 he didn't take note of, my lord.
Even he says that it was a discretion of the
Authority
because it says that right is not there, but sub-rule 2 creates a right.
Sub-rule 2 creates a right, but that is in the case of suspension. I am holding a judgment, my lord. Only one copy, one offense.
Whether 91 has been referred to in the light of this.
So it is a 2004 judgment. For a moment, your lordship, I use para 3 only. I may be excused, this is the single copy.
Yes, yes.
Para 3.
Well, yes.
The packages go to the statement. That
There are subsequent judgments taking a departure from.
Only one thing so had to propose the hearing. Then 91 2 possibly, since the word suspension is there, it is in terms of a disciplinary proceeding, not in 91 2. Suspension, what is there? It relates to a service disciplinary proceeding, cannot be a criminal proceeding. Possibly. We are bound by that. I just clarified.
You wanted to say that the sub-rule 2 applies in a different situations.
That's what.
And sub-rule 3 applies in other situations. So there cannot be any overlapping of those. So there is no difficulty. Understood. Yes.
Item number 20.
Item 20 and for the appellant, my lord, there is an IA number 1363 for formulation of grievances.
It's not only question of days.
How much delay?
43 days.
43 days.
Yes, Your Lordship. We wanted to file an objection. I would not have filed because it is 43 days.
Bad bench.
No. I would not have filed it because this is 43 days. But when you went through the writ appeal, Your Lordships, what we found is, I'm very sorry to say this, we were the writ petitioners. So what the appellant has done is, he straight copied our averments to this writ appeal to the extent that saying this, that our case is right and his case is wrong. So therefore, there is no substantial justice involved. I mean, so therefore, why should the court at all entertain a writ appeal which has no substantial justice? That's why I take both the points.
Have you seen the latest trend of the
Supreme Court?
The judgment of the Supreme Court by Justice Mittal, Justice Pardiwala. These line of law, Section 5 says, even Justice Mittal has said that at the time of considering an application under Section 5, the court should not look into the merit or the demerit of the case.
Absolutely.
Though in 1996, 1997 era, the Supreme Court invariably in many judgments says that the meritorious cases should not be nipped in the bud. The court will see that if there are some minor lapses hither and thither, if it finds, then the court should condone the delay in a more liberal manner. So now these are the situations. He has come up 42 or 43 days delay. You may be right in your contention at the time when the appeal of the interim order is.
Lordship, I was aware, Your Lordship say that is why we are filing 3 sets of objection. One is to this, which of course.
Straightway talk about this.
Lordship, I would not press much upon it. No, I have 2 more objections to file. One is to the very admission of the writ appeal, and one more objection we are filing to the state.
The admission, madam, will arise after the condonation. So long the
Your Lordships have already expressed
the court will go into admission.
No, I just said that because Your Lordships already have expressed that it's a bad bench for pressing my objection.
No, that is on Section 5.
Lordships.
On Section 5.
Pardon to submit, my lord. If I have taken some of the averments, I have not totally taken
I have
everything.
gone through the averments of Section 5. Have you made out any case of a submission cause?
Yes, my lord. In the rate appeal.
I am asking you section. Look at your averment paragraph 5. Please read tell me which parts should be considered as a sufficient cause. Well, please read small petition. Please read where you have made out a case that what prevented you from filing the appeal within the time. Please tell us.
Sir, my lord, in the third paragraph,
Please
and it is for my lord,
read.
there has been a delay of 42 days in filing the writ appeal petition. Such delay is neither deliberate nor intentional. Present petitioners were unable to collect necessary documents on time, for which they could not file the petition within the duration of limitation. My lord, during this writ petition, when my lord,
What were the documents? When you gather the documents, will you not?
my lord,
spell out?
I will absolutely show that maybe my learned senior is affected by some of the paragraphs, because it is we are learning
Forget
from
about it.
we are learning from the senior.
Taking that submission into consideration at
In
this
the
stage.
writ petition, while
At this stage, we are not. You please concentrate on sections.
For the report, even and hide many documents and all written note, release,
my lord, I was not able to. I'll just say one thing, that because of the consideration of the writ petition in the past, the 43100 writ petition, there was another writ petition that was filed before the judgment was passed. There are two writ petitions. This writ petition's judgment I have challenged. There was another writ petition that was filed by the present appellant, which had a specific. My ground is there. I have solid ground in this case when it comes to admission of this argument. When it comes to, it's not just one writ petition alone. There are one more writ petition. There was a direction in that writ petition. In that direction, before compliance, it was an honorable High Court's judgment order. Before compliance of the same, there was another writ petition filed by my learned senior, where there was no mention about the previous writ. But still, in their prayer, cancellation of the prayer that was asked in the previous writ is written in the second writ petition. My lord.
Show us where you have stated all these things in the section 5.
Section 5, written in the writ appeal, my lord, on stage of admission.
Can the court look into the writ appeal because section 5 has not been allowed?
Normally pressure to allow. It's a short.
There must be a ground.
Only 43
Look
days.
at the language of section 5 of the Limitation Act.
I admit, man.
The court must form an opinion that yes, you were prevented by a sufficient cause in not preferring the appeal within the statutory period.
I will honestly,
you have to understand.
Can I submit the latches in the court? My honest.
Please tell me that whether those paragraph 3 or 4.
The latches on my part.
Sufficient ground.
The latches on my part being that it is was very difficult case for me to analyze, and I did it as hard as possible, but it was because of my own latches. Mano.
Provisional for termination in respect of writ appeal. So perhaps the provisions are similar. There it is good cause. Not sufficient cause, it is good cause. So where are you sure?
More stringent.
I will normally pray to allow the IA. I will try to satisfy my lord in the permission stage. If at all my delay is condoned for this.
What's the purpose? That's why I'm saying that Supreme Court judgment of this delivered by Justice Mittal says that while sitting an application under Section 5 of the Limitation Act, the court will not forget Section provision of Section 3 of the Limitation. Must bear in mind the provision of Section which curtails your right.
Otherwise, I humbly pray that if the delay is condoned, it is a very good case. I want to really submit it in front of my Lord. During next future appeals, I will keep this in mind.
You already have the objections. And of course, one of the objections is already your lordships have expressed the same objection we have, apart from that other objection. But I would leave it on your lordship's wisdom, would not be very pressing on the issue of limitation, because I am also very sure that this is not fit case for limitation. So, and the anxiety of the young lawyer versus me also, that let him put his case. It is. I mean, of course, limitation is cannot be an exclusive ground, and so many matters have gone from here, are being remanded back from Supreme Court also. That why was it dismissed only on a point of limitation? So I don't know if it sees the fate, it may come back again. So it will be unnecessarily a double wrong. I'll leave it to your lordship's wisdom on that issue. But we file an
the application for condonation of delay of 43 days in the
the admission day comes. Otherwise, my learned senior was saying already if he's trying to create an opinion that I'm wrong, I want to say on the stage of admission, I may be allowed to submit the case.
What do you think? Till this time,
Right now, otherwise my senior will say that I'm wrong already. Creating a opinion.
Have not given you an adequate, and I believe in that particular affording an opportunity more particularly to the young lawyer. Because
I will try my best.
I consider them as the future bar. So if they do not get an adequate opportunity of hearing, then I don't think that I will be doing a justice to.
Obliged.
So that's why again, sometimes I just give you that please think about the matter in this particular manner, just to make a bar strong.
Try to
Why
make.
you inculcate a sense that you will not be given an opportunity to place your case on the day of admission?
Possibly, he couldn't express it. Possibly he would.
But I am.
To improve upon. What my learned friend said, actually, I was going through the writ appeal petition. One cannot follow what he intends. Many times he has said the prayer of
So that's a defective
Yeah.
drafting. And the old notion of the Privy Council stage or federal court stages, there is a concept of a mufassal drafting. I will come across with the judgment of the Supreme Court on that mufassal drafting to be literally construed. So you are not making a mufassal drafting. What is the rural area structure? So do not put more prudence or rigidity to the problems in them. Any.
Item 21.
In item 21, my lord, there is a noting here also, my kindly 25,000 we have to deposit before the High Court bar. We have deposited, but it is reflected in the contract. It has not been deposited.
Any shift?
Okay. Where is the order?
Order dated 6th of May. Yes.
Yes, deposit.
My lord.
You are for the appellant.
I am for the appellant. Safety.
You proceed for today. Can you proceed?
Yes, if you also desire, sir, I can proceed.
Yes. Pursuant to the order dated 6/5/2025, the cost has been deposited with the High Court Bar Association and the Trades Welfare Fund. Senator, a receipt whereof is.
Receipt copy.
Today, when is the receipt?
Yes, my lord, you could write.
Right. In court today, which shall be taken on resolve.
Right.
The appellant intends to proceed for admission of an appeal. Yes, now you can argue that.
My lord, I have-
further order.
My lord, my direct, my learned friend to serve me a copy of the appeal memo.
We have not, sir.
No, my
I just thought that.
No, only limitation matter your lordship has had. I will serve a copy today.
What we said. At this stage, the counsel for the respondent, you are for?
My lord, sole respondent.
No responsible. The respondent submitted that the copy of the appeal has not been served upon.
Just now I will. Just now.
So that is directed to serve the copy Reports of this day or tomorrow by tomorrow?
Just now I am giving one.
Sir.
With advance source. Hands over the copy of the writ appeal to who is your advocate in the court, who will receive.
Yes.
What is court today? When you want, Monday? Monday, matter to be disturbed. You want to peruse?
Wednesday, right?
Why?
I thought Monday I have some difficulty.
Why not Monday?
Even
Monday. Yes, so if you want to, we receive, we begin on this one. Before our attention is drawn to particular kind of ministerial error crept up in the aforementioned order, where the amount of cost has been wrongly described in wonderful language. Instead of rupees 25,000, it has been wrongly recorded as 20,000. Such mistake is evident that happens and change ministerial in nature. The word to report rupees 20,000 shall be rated as rupees 25,000. This order shall be read next order. Last thing, this order shall be read conjointly with the order dated 6/5/2020.
Item number 22.
Videoing has been filed. Only read.
So this is the demolition of your.
Yes, ma'am. Houses, stops and all. I have given the decisions as you know. Oh, one copy I have given.
Yes, yes, that was already there. I could not find time.
Second copy I have given one.
What second copy?
Argument.
Again a copy. How many times?
No, one copy I have given, but the second copy I have given. Because the memo for short notes.
What's this? The government advocate appearing for you are for the response.
Filing the bill.
Sir,
Because of filing the bill.
sir,
Because of the.
I think notice is given.
No, my lord, this is
For the right has accrued, so that he is entitled to notice. Though we will condone it, but he is entitled to.
Just date each party. Notice office.
Go to the commission. Notice has to go to respondent. You do 1, 3 and 4. Yes.
This is a case of demolition of his house matters from quotation, notice by go matter, quotation from quotation.
We are giving you a short notice, immediately by the requisites now. We are fixing this matter even after 10 years.
Right.
I may be permitted to take notice through special messenger.
Is there any provision here? There is a special resolution. Yes, you deposit the cost. Tomorrow, my lord, I will provide you. Fishing vessel.
Through my lord, respondent to. Respondent to. Yes.
Item 24.
Madam, before the learning starts, if I submit one line, my lord. Madam, this matter has become infructuous now, my lords. Because my lord, the RFP under challenge, the validity of that period was 90 days. And the contractual provision under that for whatever period it has to be given was for 2 years. And this is for 21, my lords. And that period ended in 2023. And now, my lords, the department wants to go ahead with the fresh tender because of there is a status quo order of 2021. The department is unable to go ahead for a fresh tender, my lords.
There is a case of also, there is an allegation of undue favor. Yes, pursuant to status quo order, Miller, it's a supply of manpower.
The
Supply of one player. Supply of one player.
My lord.
Miller, what I am saying, your lordships, they
The period already over.
yes, yes, Miller, they
And
if
under
they
the
want
garb of
retender,
the
Miller,
status
pursuant
quo
to order, I
order,
am providing the
since
service, Miller.
2021
Till finalize of
continuing.
tender. Sorry, your lordships, I challenge the tech rejects.
He's continuing with the service.
Yes, my previous contract where he was given, that contract ended in the year 2021. Because of the status quo order, my lords, that he is still continuing with that contract.
More than the period for this.
Yes, my lord. Yes, my lord. Yes, my lord.
Based.
No, I am not saying, your lordships, only I am saying, till finalize of tender, maybe continue, 51%. Till finalize of that tender. That's subject to your lordship mercy, but because I have no subject.
More than the period for which your engagement was done, and you have already. You don't know.
Yes, Milord. I have already have rendered service, Milord. They have accepted the service.
What is the nature of the service?
Manpower. Hiring of manpower.
Where?
In the water and sanitation mission of the Orissa government.
Water and
Sanitation mission.
Do you require manpower? Because I think it is the services which you are bound to give. Yes.
There was a tender, my lord. Earlier you
I
were.
understand.
Yes.
Since the continuity is still there.
Yes.
So definitely their services must be, because you can't hire without a tender.
Pilot.
Pilots, to that effect also, my lord, there are various allegations made against the petitioner, my lord.
When you take a, but how can you substitute it without a tender?
Of course, my
Can
lord,
you,
without.
can you stop that particular services? Because these are the essential services. Education, so you're talking about, can anybody name which place, or any part?
The department wants to go with a fresh tender, of course.
You go.
Yes, my lord.
Prevents you.
Yeah, because.
So long that is not finalized, what to do? Because it is the essential service.
My lord,
Is it not?
my lords, only my lords, my lords, to that effect, I have nothing to say, my lords. Only to that effect, the petitioner has not been paying the contractual dues, EPF, and that matter is also pending in other matters. So there are allegations against the present petitioner also, my lords. He's not making payments.
You are not releasing the
Because
salary of the
status quo
employee,
order,
51%.
he cannot
You are
go
not.
ahead, and there was contempt.
Lordship by direct, my lord. You should comply with all the stipulations
Yes,
which
my
are there in the tender, my lord. As per that.
As per the conditions of the tender, they have to comply within 15 days.
Yes, sir.
And if they do not comply, then those rights will be taken.
Yes, sir.
Fair enough?
And the press tender, my lord, the body may be granted.
No, status quo is lifted, then what remains?
Yes, sir.
One.
That would suffice. That would suffice.
Well, it's,
I have filed and also the government has filed. Water Sanitation Mission has filed and the government has also filed.
That's so cool.
7013.
well, it's 701.
State and corporate both are filed. both petition of state, two application filed, one by opposite party 2 and 3 and by the state, my lord. What I'm saying, my lord, I will comply, my lord. The lordship is very, I am admittedly I am continuing more than the 51 person who was under the job, my lord, they will receive because of this pendency, they are not releasing the salary, my lord.
Well, let's do that effect. My lords,
Your lordship, they may fairly submit that all salary has been released.
My lords, there are allegations against the present petitioner, my lords, that he is not paying the dues, EPF and all those things to the persons he have engaged. Because of that reason, the payments were not released, my lords. It's mentioned.
EPS will be deposited to statutory authority, my lord.
They will reimburse that.
No, my lords, it was paid, my lords. It was paid till 2024. Thereafter, my lords, if I may refer to my IA, my lords, thereafter various allegations were made by the persons he only engaged, my lord, that EPF and other statutory dues are not deposited by him. And various
The authority will take action against them.
Appeal is pending before the appeal.
my lord, that is also as per the contract he has signed, my
Just
lord.
that you can't stop that. You are taking somebody has come and made an allegation and you stop the payment.
No, my
Do
lord.
you know the cascading effect of that? You are showing your concern to the persons engaged by him. And you stop the payment. Then what is the ramification? What is the effect?
My lords.
Can you realize?
My lords, one submission, my lords. To that effect also, my lords, as per the contract he had signed, my lord, he's not adhering to those contract conditions, my lords. And also because of in the garb of the status quo order, he has been continuing, my lords, and he's saying there's no fresh contract.
Now, if the status quo was passed at a stage when you were making the payment, suddenly you stop the payment. Can you realize that an unscrupulous litigant like him can take what steps?
Yes, there's a matter pending to that effect, my lords, in this honorable.
I'm really surprised that what is that matter pending?
To that effect.
The appropriate matter should have been immediately taken up.
But still the finalization of the fresh tender.
Make the payments directly to them.
Yes.
Engaged person. Make the payments directly to them, not to him.
To the persons.
Yes.
Well, I'll take instructions, my lords. Yes, please.
Including statutory dues. Even
persons
EPF,
not
ESI, I have to deposit in the statutory authority, no?
To the persons concerned, we can, subject to, I'll take instructions, my lord, not to the petitioner, my lords.
The direction that would be passed, no instruction.
Yes, my lords. Yes, no.
But with the rider that mere payment does not really create any equity or any right into those persons for regularization in the government service. Because if make the direct payment, they will come that I have received the payment from you directly. So I am your employee.
Yes.
That light lots by disposal.
Please.
If I my lord.
Let's dispose of the matter. Yes, sir. Please.
I will be pardoned, my lord. I will notify.
Now, what I feel is that though I came here just to give an opportunity to everybody to the police, they should not think of it. But now I have to be a bit, not to give full opportunity, but I have to go fast. Don't worry, when I return, I will definitely.
Make us.